Court rise. Appeal in the matter of Penhallurick and MD5 Ltd.
Yes, Mr. Kelly.
Lords, I appear for the claimant appellant, instructed by virtue of this legal. My lady friend Mr. Conway appears for the defendant respondent, instructed by Mrs. Lupton Fawcett. Well, hopefully you've obviously seen the skeletons and the bundles. Can I apologise straight away about the state of the bundle 2 supplemental bundle?
It's rather full.
It was rather full, and hopefully the extra bundles did reach, my lords, to allow you to relieve the overfullness of those bundles. But I have decanted some parts of my bundle supplement into a separate bundle, and so we did file some additional bundles to allow you to do that. Hopefully that has come through.
It didn't make its way to me, but I know that my lord and my lady have adopted that course anyway.
Yeah, okay. Because I really found in preparation the bundle fell apart at least 5 times before I lost patience and got a new bundle. Well, to add to the problem, of course, there is a few more documents which get added into the back of the supplemental bundle.
Yes, I did receive those, thank you.
That's by consent of the parties. Obviously, you need permission for that. Probably more appropriate just to sort of deal with those as and when they come up, because I think it's certainly one of them is something I'll be referring to, and no doubt my other friend will be referring to some of the others in due course.
All right. We haven't managed to overfill the split supplementary bundle.
Well, yes, that was a problem that I had. Yes. Well, the nature of the case, I think, is summarised in the skeletons and also in the judgment. It concerns a software written by my client, that's common ground, called Virtual Forensic Computing, or VFC. And the judgment summarises very well what VFC does. If I can take you to the judgment, you'll find the core bundle behind slide 8. And then Judge Hacon summarises it, paragraph 4. The agency is typically the police may wish to analyse the content stored on a computer without, by the act of searching, corrupting or otherwise altering the files and thereby compromising a prosecution. Mr. Penhallurick worked on a method of retrieving an image of a hard drive without writing on it, then booting up the image on a virtual machine so that the image could be investigated. Mr. Penhallurick used a freely available product called VM software to set up a replica of the target computer's hardware and operating system. Computer programs generally have inbuilt safeguards to prevent them being manipulated in this way, so part of Mr. Penhallurick's method involved a password bypass feature which he developed. But it's quite useful, I think, at this point, as we're here to go on to read the judge's summary of the development of VFC, which between paragraphs 5 and 12. And his paragraph 5, he deals with the background. Mr. Penhallurick conducted research in this field while studying for the MSc at Cranfield University between 2002 and 2005. His work resulted in his master's thesis, consisting of a description of his VFC method, an abridged version of which was published by the university in September 2005. The method was manual in the sense that although it used proprietary software, it was not performed automatically by the operation of software. I'll just pause there and say that there's a slight tendency to regard this as being just tinkering with well-known open source materials, but of course it's a much more complicated process than that which my client was going through. Otherwise, other people would have done this, and otherwise we wouldn't be here arguing about a product which has proved to be extremely valuable. So it's not just a matter of finding some open source software and just knocking a program together. It's actually a much more complicated process than that. Picking up again paragraph 6, Mr. Penhallurick says that in 2005 and 2006, while still developing his VFC method, he wrote his own software, which would allow a computer to perform the method automatically. He also began work on a graphical user interface and a user manual. Mr. Penhallurick's employment by MD5 began on the 6th of November 2006, and according to him, he was employed to assist with forensic casework supplied to MD5 by police forces. His primary duties were to carry out forensic computer investigations, prepare witness statements, attend court, and give evidence. MD5's case is that Mr. Penhallurick's duties were more flexible and extensive than this. MD5 further said if Mr. Penhallurick had created any VFC software before the start of his employment, it formed no part of the VFC software created for MD5. By early 2007, Mr. Penhallurick had developed software which permitted a fully automated version of VFC, including a graphical user interface. Both he and MD5 at the time referred to this as VFC version 1. According to Mr. Penhallurick, it incorporated code written before his employment. He also says after he joined MD5, his work on his software was done outside the scope of his employment using his own computer and primarily his own time. MD5's version of events is different. The manual VFC method which Mr. Penhallurick brought to MD5 was slow and cumbersome in about January 2007. And I ask you to note that date there. It is the evidence, there is a dispute about that, and the judge at this very point is saying that the conversation was in January 2007. Mr. Green and Mr. Boyd of MD5 discussed with him the possibility of developing software to implement his method. All such software was created by Mr. Penhallurick following his discussions with them and as part of his duties as employee. Following the completion of VFC version 1, Mr. Penhallurick created 3 further versions of the VFC software released in April 8, May 2014 and August 2016, all built on version 1. Mr. Penhallurick's case, these 2 were created in his own time. MD5 says that like version 1, they were developed in the course of his employment as an employee. And just filling in some of the extra factual dates for the chronology in there, you'll see that it's common ground that Mr. Penhallurick started his employment on the 6th of November 2006. There's a dispute as to when this conversation took place. You'll see the judge there said it's January 2007. That's my client's case as well. But as you'll see later on, the judge changed that and said actually it was in December, based on the evidence, or possibly November, based on the evidence of Mr. Green, which I'll take you through in due course. The work then was written in the course of that early period, and various versions were released. April 2008 was the second version. That was followed shortly afterwards by the November 2008 agreement, which you'll be taken to. The November 2008 agreement is important for 2 reasons. Firstly, it gave Mr. Penhallurick a bonus on sales, and there's a dispute about what that bonus meant. My client says, in fact, it's like a license fee. The claimant says it's just like employment remuneration. So there's an issue on that. And that 7.5% bonus was subsequently increased to 10% in 2011. Also, the November 08 agreement is important for the assignment point, which the defendant's fallback position, if it didn't own the copyright as employer, it acquired copyright because of an assignment in that agreement. The final relevant data, you'll see that the last version was August 2016, but that's after Mr. Penhallurick actually left. He left in April 2016, and there was a consultancy agreement between the parties then, under which Mr. Penhallurick says he gave them a license to continue exploiting the software, although of course the defendant says that wasn't a license, it was just confirmed their rights. But in any event, he was going to be paid £5,000 a month by way of a retainer for the consultancy on that. So that's really the opening chronology. It's common ground that Mr. Penhallurick created the methodology, and by this I'm talking about the manual methodology, the non-computerized methods, well before he had any involvement with the defendant. Indeed, as you've seen from the judge's summary, it was the subject of his thesis in Cranfield University in 2005, and Mr. Penhallurick's evidence was that he was advised at the time that he was at Cranfield not to write software then because there was a risk that he wouldn't own the copyright in it, and he wanted to retain the copyright. So the issue before the judge and today is that when did Mr. Penhallurick create the VSC software, which embodied that methodology, and in particular, did he do that in the course of his employment with the defendant? Well, the case it was heard in IPEC, and it was a 2-day trial before it was under Judge Hacon, which was heard on the 2nd and 3rd of July 2020. And the judgment was handed down on the 15th of February 2021, which is about 7.5 months later. The judgment is concise and it's clear, and essentially the judge found in favour of the defendants. He found that what we are calling works 1 and 2, which we said the works created before employment, either didn't exist, or if they did exist, they'd been abandoned. He then found that the rest of the VHC software had been written by Mr. Penhallurick as an employee and in the course of his employment, and therefore, under Section 11 of the Copyright Designs and Patents Act, copyright vested in the defendant, the employer. In the alternative, he found that even if that was not the case, copyright had been assigned to the defendant by the claimant under the 2008 agreement. There was some small comfort to the claimant in that the judge dismissed the 2 counterclaims raised by the defendant. One was a counterclaim for breach of contract, which is no longer active. There's no appeal on that dismissal. He also dismissed Mr. Claim for infringement of copyright, and that is a subject of my learned friend's cross-appeal today. Although I suspect it shouldn't take much time because in the defendant's own case there's been no damage suffered as a result, even if there has been infringements. Well, turning to the appeal then, there's very little, I would submit, very little dispute on the law. This case is essentially a case based on the facts, which is why obviously it's not an easy one for any appellant to raise. Essentially, it's in how relation to the judge dealt with the facts at the trial and in his judgment. However, I think I will take you just briefly to the law, which is summarised by the judge at paragraph 56 in his judgment. He sets out section 11. Section 11 of the Copyright Science and Patents Act 1988, the author of a work is the first owner of any copyright and it's subject to the following provisions. Subsection 2, where a literary, dramatic, musical or artistic work or a film is made by an employee in the course of employment, his employer is the first owner of any copyright in the work, subject to any agreement to the contrary. And then over the page, the judge set out the useful guidance from Mr. Stone, sitting as an IPEC judge in the My Fields case, paragraph 42, and he said there, I accept, as put to me by both counsel, there is no single test to be applied. Rather, it seems to me that the question of whether or not given acts were carried out in the course of employment for the purposes of section 11 is a multifactorial assessment to be based on all the circumstances of the case. In most situations where an employment relationship has been conceded, there will be some factors which point to the copyright work being created in the course of that employment and some factors which point otherwise. The relevant factors may include A, the terms of contract of employment, B, where the work was created, C, whether the work was created during office hours, normal office hours, D, who provided materials for the work to be created, D, E, the level of direction provided to the author, F, whether the author can refuse to create the works, and G, whether the work is integral to the business. My Lord, so essentially it is a multifactorial assessment, which is obviously why it is a difficult case to run when you're criticising a judge for the multifactorial assessment that judge made. And I, as I said out in the skeleton, I acknowledge those difficulties, and they're referred to in the passage in the White Book, which is in the authorities bundle. I don't know if my Lords wish to look at that, but I think you're pretty extremely well aware of the principles on the feeding.
Yes, I think that's fair comment.
So, I won't then trouble you with that. But my Lord, I think it is worth going to the Martin and Coogan case, because it does set out in an IPEC context the sort of factors which a judge has to bear in mind when carrying out an assessment of the facts. And my Lord, obviously, Lord Christopher Floyd will be very well aware of this case because it was one of his decisions. Now, this is the fascinating case about Florence Foster Jenkins, the well-known, use the word singer in the loose sense. You'll see it's in divider 6 of the authorities bundle. Paragraph 3, Justice Floyd sets out the background. After a 2-day trial in the IPEC, again similar to the present case, during which he reached the rival protagonist across his own for half a day, his Honour Judge Hacon, the judge, declared Mr. Martin to be the sole owner and sole author and owner of the copyright. Well, so if we can go straight to paragraph 70. There were, of course, other issues in this case. There were issues of errors of law as well, but I'm just referring to the factual errors of fact which were relied on in this case. So paragraph 70, Justice Floyd summarises he's looking at the judge's judgment, and he says that the judge then embarked between 57 and 61 on a lengthy consideration of the reliability as a general matter of the recollection of witnesses. He started by pointing out that, unsurprisingly, main evidence of who did what came from Mr. Martin and Miss Coogan. If I just pause there briefly, in this case, Martin Coogan is a factual dispute between two witnesses, and that also takes place in the present case for what happened after employment started. After employment started, there's a dispute about when the relevant conversation took place between my client and the defendants, and what was actually said. So that's analogous to this. But of course, the period before my client started employment, up to November, there's really only one person who knows what happened, and that's my client. And so his evidence on that is the only first-hand evidence. Anything against that is based on inferences or documents. And that's I'll come and obviously deal with this in some detail, but that's going to be an important point when assessing how the judge treated the evidence of what happened before November. Carrying on in Martin Coogan, the evidence of Mr. Martin and Miss Coogan contradicted that of the other. His overall impression was that both were stating their honestly held views. He accepted that this superficially makes no sense, but proceeded to explain his approach by citing at length the observations of Mr. Justice Leggett as to the fallibility of human memory in the Guestman case. The judge understood those passages and admonition are the best approach for a judge It's based little, if any, reliance on the witness's recollections of what was said in meetings and the conversation is said, based factual findings on inferences drawn from documentary evidence and known probable facts. What I do is obviously when you've got two people with first-hand knowledge saying different things, it's obviously sensible to look at documents and to draw what inference you can in order to test those. So I don't think it's a criticism of the judge for looking at the documents to test the inferences, but I think as you'll see as we go through, the criticism was that that's not a reason to completely ignore the evidence of the witnesses. But the judge then, Justice Floyd then set out in paragraph 7 what the judge carried on to do. Just picking it up about 4 lines down in paragraph 71. At paragraph 78, he found Miss Cogan's technical contributions to sole right were limited to contributions to technical musical language incorporated into drafts 1 to 3. The judge went on to reject Miss Cogan's claim that most of the remainder of the text had been co-written by her with Mr. Martin. He accepted there was some limited evidence in support of this, considering of an email which Mr. Martin referred to Miss Coogan as his special collaborator, and an email from Miss Coogan in which she said that it was such fun for me to work with you on these things with you. These were, however, very early days, and the affectionate language of emails gives little idea of how Mr. Martin and Miss Coogan planned to work together on a subsequent writing of the draft screenplays. And then he goes on to look at his judge's paragraph 81. By contrast, there was more telling agreed and documentary evidence which suggested that the first 3 drafts were written by Mr. Martin alone, with very limited help. Well, it's carrying on to paragraph 72. Justice Floyd comments that the judge made his various findings true to his belief that he was following the approach from Guestman, i.e. looking at the inferences drawn from the agreed documents and disregarding assertions made by the witness, Miss Coogan. Picking it up at paragraph 76 then deals with the grounds of the appeal. And halfway through, or just under halfway through, grounds 3 and 4 of the judge's assessments of Miss Coogan's textual grounds 3 or 4 focus on the judge's assessment of Miss Coogan's textual contributions to the rehearsal scene, the scene in the lift, etc., asserting that he ignored the true nature and extent of Miss Coogan's contribution, ignored key documents, ignored key passages across examination. Ground 5 asserts that the judge's assessment of Miss Coogan's non-textual contribution is flawed, in particular his assessment of the Lee Pond scene and the Pell song, the McMoon audition scene and the scene in Melatonin Homophone Records, where Florence takes charge of the action herself. Ground 6 asserts that the judge erred by failing to take account Mr. Coogan's largely unchallenged evidence detailing her full contribution to the writing of the screenplay. Well, as we then flick over to paragraph 86 over the page, and counsel for the appellant, Mr. Malinette, submitted that the judge had wrongly and unfairly ignored Miss Coogan's evidence contained in her witness statement and its Annex A. Annex A was a detailed scene-by-scene analysis of Miss Coogan's contribution to the screenplay, which was largely unchallenged. It was not vague and rambling, as the judge had unfairly characterised it. The judge's statement that he considered it short for trial was not a ground for dismissing it. The witness statement had been served in accordance with judge's directions 5 months before. Now, we say the similar in the present case. You'll see that the judge didn't take into rejected the significance of certain pieces of evidence on the basis it was too confused and inconsistent to place any reliance on. And he did that in relation to some of my client's evidence, and he also did it in relation to some of my friend's evidence, the evidence of Mr. Clark, which dealt with that. So he said it was all too confusing. He just put all of that evidence out of his mind. And we obviously, I think we would both say that we don't think that evidence is inconsistent or confusing. We both seek to say that it provides support for our cases. Mr. Weisselberg's response, I'm picking up paragraph 87 in the judgment, was that Annex A had not been ignored by the judge, who must have read it in order to describe it as he did. The judge simply did not find it helpful and preferred to test Ms. Coogan's case by reference to the 6 best contributions, assisted by a colour marker. And then paragraph 88, Justice Floyd says, we think there is real substance in this ground of appeal. We start by recalling that the judge read Justice Leggett's statements in Guestman as an admonition against placing any reliance at all on the recollection of witnesses. We consider that to have been a serious error in the present case for a number of reasons. First, it's been recently noted by His Honour Judge Gore in CBX against the North West Anglia NHS Trust. Guestman is not to be taken as laying down any general principle for the assessment of evidence. It's one of a line of distinguished judicial observations that have emphasised the fallibility of human memory and the need to assess witness evidence in its proper place alongside contemporaneous evidence and evidence upon which undoubted or probable rights can be placed. Well, so picking it up on the top of the next page, the top end of the first line, but a proper awareness of the fallibility of memory does not relieve judges of the task of making findings of fact based on all of the evidence. heuristics and mental shortcuts are no substitute for this essential judicial function. In particular, where a party's sworn evidence is disbelieved, the court must say why that is. It cannot simply ignore the evidence. No, we say that's applicable in the present case. I was picking up paragraph 90. Thirdly, having decided to follow the Guestlin approach, the judge did not apply it to documents which greatly assisted Miss Coogan's case. Two documents to which the judge referred at 79 strongly supported an inference that the parties were collaborating on a screenplay at the outset, but the judge declined to draw any inference from them. Instead of observing this early in the project, in the affectionate language used, gave little idea of how the parties planned to work together on a subsequent draft. It was, however, important for the judge to come to a conclusion on the basis on which the original outline was created. So again, that's the same point there. The evidence which the judge chose to ignore as too confusing or inconsistent were matters he should have looked at more carefully and should have put into the pot in deciding whether or not the evidence of my client should be accepted. Paragraph 91. The judge's inconsistent approach to documents is also apparent much later in the process. In a draft email, albeit in the context seeking to find Miss Coogan in a position as voice coach for Meryl Streep in the film, Mr. Martin said that Miss Coogan was involved in helping to develop the character for Florence. A colleague to whom Mr. Martin showed the draft described it as honest, generous and fair. Mr. Martin did not suggest he had not been telling the truth in the email. The judge does not refer to this email at all. Recourse to the Guestlin approach does not justify selective treatment of this kind. In the next paragraph, there's again reference to the judge making no reference to another exchange. That's paragraph 92. And then at paragraph 93, thirdly, the documents on which the judge relied in support of Mr. Martin's case were themselves a shaky foundation for drawing the hard inferences which he drew from them, particularly with regard to where the non-textual creative input was coming from. Whereas we say that's appropriate in the present case. A large part of the judge's judgment and my learned friend's case is based on some appraisals of my client, employment appraisals in the course of his employment. And the judge very strongly relied on those to justify his findings, particularly in relation to the pre-employment works, to raise an inference that actually my client's evidence was wrong. So I'll deal with that in more detail, but that comment is particularly relevant to the appraisals point. As is the comment of paragraph 99 in Martin and Coogan. Fifthly, the judge also placed weight, whilst disregarding Miss Coogan's evidence about them, on the public statements made about Mr. Martin being the sole screenwriter to Miss Coogan's knowledge. It is, however, hardly surprising that whilst the parties were in a relationship supporting each other in their careers, Miss Coogan did not agitate for public acknowledgement. That was her evidence, but applying Guestlin, the judge ignored it. So again, relying on public statements, the judge drew an inference which allowed him to, in effect, justified him ignoring the evidence of the witnesses. And we say, again, that's similar to what the judge did with the appraisals in this case. Paragraph 101, a separate point, we think the judge should not have criticised Annex A in the way he did, far less give the impression that he'd had insufficient time to absorb its contents. This is bound to leave Miss Coogan with the impression that the case had not been fully considered. Well, that's very much the case in the present case as well. When a judge has judgment that reams of the source code, the very material which this case is based on, is confusing and inconsistent, and then my learned friend's evidence in response to it is confusing and inconsistent, the impression being given is that the judge either hasn't received the assistance about that during the course of the trial, which may not be surprising in a two-day IPEC hearing, but it also gives the impression that he hasn't got to grips with that evidence and given it the attention it really deserved. And in many ways, we say that's why we're here today. The evidence, we would say, clearly is not confusing. In paragraph 102, about 4 lines down, the judge observed that despite his being in a romantic relationship with Miss Coogan, there's no evidence that Mr. Martin changed his mind about this, and aside from Miss Coogan's assertions to the contrary, we fail to see why Miss Martin's assertions to the contrary should be ignored. And then paragraph 103, the first 2 lines, the judge's approach in relying only on documentary evidence and agreed evidence has led him to fail to make findings on key issues. And we say again, it's similar to the present case. The judge in this case has said he prefers the evidence of the defendants. He's never really got to grips or explain why that is. There's a reference to the appraisals, for example, but other than that, there's no explanation as to why my client's evidence was rejected in favour of the defendants. Paragraph 104 then deals with the point which I'm also deeply conscious of. Lord Justice Floyd said, we're of course deeply conscious of the guidance given at the highest level to all appellate courts. The findings of fact by lower courts must not be disturbed except in very limited circumstances. Our problem is a rather different one. Because the judge has expressly declined to have regard to the witness evidence which he heard, we are left without the benefit of what might consider to be essential findings of primary fact. We're in no position to make ourselves. But we're slightly different here because if the judge says he's paid attention to the oral evidence of the witnesses and preferred the evidence of the defendants to that of the claimant, but as I say, has not explained why it is, and why the very limited documentary material, we say, which supported defendants, overrode the claimant's clear evidence, and what we say is clear evidence of supporting the claimant's case. Paragraph 105 of Martin Coogan, this is not a case where the conflicts of written and oral evidence can be described as honest differences of recollection. If the judge's findings are correct, Ms. Coogan's written and oral statements of the process creating the screenplay and the witness statement are simply untrue. Again, that's rather similar to our case. If my client's case was he wrote some software before he was employed, and the judge has said, well, either he didn't write it or it was abandoned, which is directly contrary to my client's evidence. But obviously, just a couple more points from this. There's a bit more about judges not mentioning material at paragraph 130, 131. I don't need to, I don't need to go to that, rather repeats what you've already heard. Paragraph 140 is the Court of Appeal's summary of its conclusions on this. 140, aside the judge's failure to make the issue of collaboration, we consider that the judge's summary of the extent of Ms. Coogan's contribution fails to take account of a number of significant matters. Perhaps most significantly, her contribution to the shaping of the character and the plot of the screenplay. We do not think it's possible to dismiss any of her contributions not being authorial. Paragraph 142, despite these conclusions, it would be open to us to dismiss the appeal if we are persuaded that the failure to take proper account of the matters we have referred to would not affect the outcome of the action. We do not think that course is open to us, however. We think it's entirely realistic to suppose that reconsideration of all the evidence would show that Ms. Coogan's contribution was indeed made as part of a collaboration and passed the quantitative threshold for joint authorship. It would be wrong of us to go any further in light of the disposition of the appeal which we will propose. And then paragraph 145, it's back to the point about the appellate courts and factual findings. Mr. Weisselberg reminded us of high authority in joining appellate courts from becoming involved in detailed and complex reassessment of factual findings made by a judge. That principle, he said, applies with particular strength to appeals from the courts such as the IPEC, which aims to provide a less complex and less costly alternative to the High Court. He's obviously right to do so, and we accept his submission in its entirety. However, on the basis of the grounds of appeal which we have found made out, the judgment cannot stand. The judge has adopted an erroneous approach to the evidence, failed to make important findings of primary fact, failed to take into account material matters, and applied incorrect legal standards to the assessment of the sufficiency of Ms. Coogan's contributions. In those circumstances, and with reluctance, we see no escape from the conclusion there must be a retrial. The increase in costs to the parties, of course, regrettable, and we can see no sense of alternative. But also, as is alluded to in that passage, it's very easy to feel a sense of sympathy with a judge sitting in the IPEC, where procedure is inevitably curtailed. There's no proper opening. The witness statements, you launch straight into the evidence, and you have focused cross-examinations in which the judge does not get taken to all the evidence. It places a very heavy burden on judges, and I fully recognise that burden, and particularly the burden that the judge often would have to go away and read the evidence much more carefully than he's been able to do before, because the opening won't have dealt with it. The skeletons might have gone through it, but often the skeletons that you've had time to read through just the once. So it's a very difficult position judges are in, but, and in this case, of course, there were very substantial further evidence was put in at a very late stage. And the judge made the decision to admit that evidence. Now, it may be that was the wrong thing to do, but once the evidence has been admitted, it has to be given its proper weight and proper consideration. Either, if it can't be done during the course of the hearing, it requires the judge to go off and read it very carefully afterwards and to satisfy him or herself as to what it does mean. He can't just sort of say, it's all too confusing, I'm not going to pay any regard to it. Some proper consideration must be given to that evidence.
What did the judge actually do with the evidence of Mr. Clark? Because he allowed it in, subject to arguments about admissibility, but I'd always thought that allowing evidence in was implicitly saying that it was admissible.
It's a very difficult...
Or was he, as it were, saying, well, this can be in the case, but the parties will be free to exclude it on the grounds that it's expert evidence. That must be what
that's essentially what he did.
Yeah.
And in relation to, for example, the counterclaim for infringement, his reason for dismissing that counterclaim was that the counterclaim was based on Mr. Clark's evidence,
Yes.
and he said that evidence is expert evidence for which they got no permission.
Yes.
Therefore, though the statement had been admitted as evidence in one sense, it had not been admitted as expert evidence, and therefore there was no evidence to support.
been admitted subject to its admissibility.
Again, what is it? I've got a huge amount of sympathy for a judge faced by this, because you're coming up to a trial, you want to do justice between parties, there are documents which are clearly potentially relevant, and what do? If you exclude them, one party's going to feel they're being not had a proper trial, not had a proper assessment of the merits. But if you let it in, the trial timetable is completely shot. And in this case, I mean, you've already got the 2-day limit, and you end up with a huge amount. For example, Mr. Clark's second statement is some 40 pages long of almost entirely expert evidence. And his third statement's another, I think, 15 or 16 or something pages long. And these came in. One was 10 days before the trial or thereabouts, and the other was 5 or 6 days before the trial. So at the very last minute. So the judge is in a difficult position. And what he said, I'll take you to it in a minute. What he said in his judgment is saying, I'm going to let there's no permission for expert evidence, but I've got these horrible documents, the source code. I need someone to help me with what they mean. Therefore, this evidence might help me. And therefore, I'm going to let it in and let parties make of it what they will in submissions at the end of the day, leaving it very unclear as to what its standing was. So what he seems to be saying is, insofar as I can treat this as just evidence of fact, I will take it into account. Insofar as it's evidence of opinion and expert opinion, then I'm going to ignore it. It's a very, very difficult line to draw in any expert report. Again, I can see you can see entirely why the judge did it in this case, but having let it in, he should have given all that evidence much more care and attention and consideration than he did, or said to the parties, I'm sorry, I need more submissions on this. IPEC does have the ability to have an extra day, a third day, and maybe that's what it required. But instead, maybe it wasn't apparent at the time, but when the judge came to write his judgment, it became apparent, and by then it was too late. Well, that's all I need to say about the authorities, I think. If I can then turn to the main basis of the appeal, and the starting point, as said in Mascoutin, is what the judge said and did about works 1 and 2. These are the works created for employment. Well, if I can take you to my skeleton, paragraph 16 and 17, which sets the scene for this. And I want to point to paragraph 16 that the judge's findings in relation to works 1 and 2 were a critical part of his conclusions in relation to works 3 to 8. By finding that works 1 and 2 either hadn't existed or been abandoned, made it much easier for the judge to then go on and say, well, these other works, the later works, must therefore have been created during the course of employment. Of course, as far as the claimant is concerned, the fact that these works existed and existed before any employment started, before there's any suggestion of any employment, was clear support for his case that when he carried on with this process of converting the methodology into the final versions of the software, he was just continuing a process he had done not as an employee, completely outside. So in a way, the existence of these works was key to the claimant's case. And as I say, the fact that the judge found that these works didn't exist made it much easier for him to find that the later works were done in the course of employment. I should clarify at this point. So the part of the problem, I suppose, in this case is the pleadings talk just about works 1, 2, 3, 4, 1 to 8, and talk about the VFC functionality. In the pleadings, there's no reference to what came out during the evidence, that aspects of the programs which was again agreed, were written by my client in the course of employment. And this is the distinction between the VFC core functionality software, the material he started, which just built on his manual methodology he had produced, and it was the subject of his master's degree. So the core VFC functionality, the stuff which allowed you to actually take a drive, reboot it in the virtual environment and interrogate it without changing the data, that's the core functionality. That's what my client said was his and always was his. On the other hand, there's aspects which allowed that product to go to market, which allowed it to be sold by the defendant, we say as a sort of mutual benefit. So this is matters like the securitization of it, adding the dongle so that only proper people with licenses could access it, and then couldn't then hand it on to their friends also to access it. So security and licensing aspects of it, which my client fully accepts, were done in the course of employment, and were done so that the defendant could market this product. So that distinction runs throughout the case here. There's no issue about the latter. We fully accept that those aspects of the software were done in the course of employment. But the core functionality, which of course is severable, it's quite distinct in the programs, was derived from the pre-employment methodology, the pre-employment software, and was created by my client outside the terms of the employment. Well, the starting point on considering works 1 and 2 is that the issue whether the claimant wrote something before he was employed is something uniquely within the claimant's knowledge. The defendant's witnesses could have no first-hand knowledge of that whatsoever. So on that basis, the judge's assessment of the claimant as a witness is
Well, can I just test that for a moment? One can see why you make that submission, but hypothetically, suppose it were the evidence of the defendant's witnesses that when your client arrived, he had said to them, I haven't written the software yet.
No, I accept that, yes.
That obviously would be capable of bearing on the question.
Well, absolutely right. And there could be explanations for that. I just didn't. I was embarrassed because it wasn't good enough, or I hadn't finished it. I just didn't want to tell them anything. Maybe reasons for it, but clearly, yes, that's evidence which the judge can put into the pot. But there's still an element of inference in that. The primary evidence is the person who actually said, I did this. I actually did create this software beforehand. But my lord, yes, I do accept that. And that, of course, is exactly the sort of evidence on which the defendants were relying. They were saying that when he joined, he didn't mention he could write software. He didn't mention he had written software. Therefore, we would say that possibly a reason why it wasn't within the scope of his employment when he did write it. But yes, those sort of matters that they rely on, and as you'll see when I take you to the judge, that the judge also relied on in coming to his conclusion as to why he could, in effect, disregard the claimant's evidence. But well, the starting point is to look then at the judge's assessment of Mr. Penhallurick as a witness. And he deals with that at paragraphs 28 and 29 of his judgment. So this is in the core bundle, divider 8. Page 84 of the bundle. So paragraph 28, Mr. Penhallurick gave clear and direct answers to the questions put to him in cross-examination. He made realistic concessions during the course of what appeared to me to be an honest attempt to explain matters as he saw them. Time was taken up with questions about comparisons of source code. This arose from disclosure given by Mr. Penhallurick very late in the day. It is enough to say here that the disclosure neither assisted nor damaged Mr. Penhallurick's case, and I do not think the answers he gave about the late disclosure affected his credibility. So that's all that the judge said about Mr. Penhallurick. There's no suggestion in that of any feeling of unreliability. Instead, the suggestion is of an honest witness and a credible witness. Nothing affected, the late disclosure, for instance, did not affect his credibility. There's no suggestion in there. There's a reason in the demeanour of my client, or the way my client gave evidence, as to why his evidence should be disbelieved. And my client's sworn evidence was that he had created some software in September 2006, before his employment, and that elements of that software have been carried across into the later software, the version which he said he wrote in December 2006, and into the versions subsequently marketed by the defendant. And the judge summarised my client's evidence at paragraphs 43 to 48 of his judgment. And it's probably easier if I ask you to read it yourselves. Paragraphs 43 to 48. Well, just to highlight a couple of points. In paragraph 45, you'll see that the judge mentions that Mr. Penhallurick was offered a 12-week contract with MD5. Well, that's correct, and that's certainly my client's case. It was a temporary contract, and the judge refers to this 3 times in his judgment. Also, paragraph 14, sorry, 4 times. Paragraph 14, paragraph 30, this paragraph 45, and paragraph 59. So the judges, this wasn't common ground. The other side don't seem to have accepted it as a temporary contract, but the judge clearly found that it was a temporary 12-week contract that my client was embarking on in November. The second thing I'd comment on in paragraph 46, you'll see that it says there, within weeks of joining MD5, Mr. Penhallurick shared his manual VFC method with the defendant, and that's common ground. That's absolutely what we say. The final paragraph, paragraph 48, I think gets to the crux of one of the later issues that will come up when we could deal with works 3 to 8. Ms. Penhallurick later said in cross-examination the breakthrough came in the last weeks of December, and he demonstrated his software to Mr. Boyd in January 2007. On the other hand, when taken to a page of source code, which had been created in 23rd December and last written on 3rd December, he said that this had been the first method of automatic methodology. Well, I'll come back to that later, but you'll see that the December-January dates become key to the works 3 to 8 issues. So that was the claimant's evidence. And given the judge's assessment of Mr. Penhallurick as a witness, as a credible and honest witness, and given the fact he's dealing with matters uniquely within his own knowledge, one would expect there'd be some fairly cogent reasons to justify rejecting that evidence, as the judge did. Particularly as I say, the defendant's witnesses could have had no direct knowledge of the matters. It would be simply based on inference, or the sort of matters my Lord Justice Arnold mentioned, later conversations which suggested that he hadn't written anything beforehand. So one needs to look at
Is it possible that the judge is saying in 48 that the evidence he gave in cross-examination was one of the realistic concessions that Mr. Penhallurick made, which he refers to in 28?
Yes, I mean, that's certainly the way that the judge took it. It's saying that when Mr. Penhallurick said in cross-examination, yes, the version in December was my first attempt at automatic methodology, the judge and my learned friend take that to mean there can have been no earlier work. There wasn't a September work, for example. But when I will take you to that passage in the cross-examination, and it's perfectly plain Mr. Penhallurick was not saying that. He was saying that I started this work in September, I continued, and I had a breakthrough in December. And that runs throughout Mr. Penhallurick's case. I will take my lords to that evidence. But yes, I think that's maybe one of the concessions that the judge felt he was relying on. But
isn't the difficulty with that it then begs the question of what Mr. Penhallurick meant when he said that, as recorded by the judge in 46, that he'd created the first and second works, that is to say the VFC software and the compiled object code, which rather suggested that he'd finished something.
Well, but there was source code in existence, and I'll take you to the evidence of that. And it wasn't a working program at that stage, it was a work in progress. But there was software in existence which had been compiled. It wasn't VFC software, which is why version 1 is the version which came out in January. So, in my predecessor, counsel in the trial referred to version 0, which is the December version, and version -1, which was the September version. The version -1 was not a working version, and no one ever pretended it was. But the software from it was carried across, and again, I'll take you to the documents on this, carried across into the later versions, and was not, as the judge found, either didn't exist or abandoned. It was clearly, it did exist, and it was carried across. Excuse me. But I will return to that and go through that evidence, because as my Lord said, it does look like, and that's why the judge relied on it, it does look like a concession saying, well, yes, you're right, I didn't do anything until December. But actually, when you look at the evidence, it clearly is not really saying. So I think maybe the judge's note didn't reflect the actual evidence given. But my learned friend Skeleton actually sets out the passage where he refers to the September date. So, but I will take you to that. But I was going to take you to my submission then is that you've got a credible witness giving evidence about something that's unique within his own knowledge, and you therefore expect something fairly cogent to justify rejecting that. And so we then look at what the judge said about that, and he sets out firstly the defendant's counter-evidence at paragraphs 49 to 51. So 49, Mr. Green said that Mr. Green was one of the directors of the defendant, that shortly after Mr. Penhallurick joined MD5, he demonstrated the VFC methodology, but not any software. That's common ground. He was not sure in cross-examination when this was, but he settled on November or early December. As counsel for Mr. Penhallurick said in closing, this was likely since it accorded with the evidence of other witnesses. Having been shown the method, Mr. Penhallurick thought that using software to operate the method would speed it up. Mr. Penhallurick had expressed confidence he could convert his manual methodology into program. Following discussion with Mr. Boyd, Mr. Penhallurick was allocated time to do this. Mr. Boyd's evidence, and he's the other witness for the defendant, Mr. Boyd's evidence was that the manual VFC process demonstrated by Mr. Penhallurick took a lengthy 24 to 48 hours to complete. Mr. Boyd's recollection was that he too thought it would be helpful to have software created to carry out the process. He discussed with Mr. Green the possibility of hiring a third party to do the work, but Mr. Penhallurick had assured them that he had the programming skills and was keen to be given the job. In cross-examination, he said Mr. Penhallurick had worked on software from January till mid-March 2007. So you'll just note there that you notice that the dates which Mr. Boyd is actually saying there is that the work that he relies on has been done in January to March. So insofar as work was done in December, you would have thought that's not covered by this conversation. That's prior to the conversation. But again, we'll come back to that when I deal in more detail with the works 3 to 8. So that's the defendant's evidence which the judge sets out. The judge then entered into his own discussion at paragraphs 52 to 55, his discussion and conclusions. 52, he says, there's in evidence a staff annual appraisal dated 31st of August 2007, completed by Mr. Penhallurick. It included Mr. Penhallurick's handwriting, the following: during February-March, and that must be 07, I was given time to develop VFC, a product which is still performing well in the sales arena, even though further development is required. The product in question is still selling well, was the VFC software. Mr. Penhallurick's own appraisal sits more easily with the recollection of Mr. Green and Mr. Boyd than Mr. Penhallurick's assertion that his breakthrough came in December. I found the evidence of Mr. Green and Mr. Boyd more convincing than that of Mr. Penhallurick on this subject. I believe that they suggested to Mr. Penhallurick that software should be written to automate the VFC method, and Mr. Penhallurick volunteered to do it. It may be that Mr. Penhallurick had done something by way of working on VFC software before he joined MD5, but on his own admission it did not work and was not worth showing to MD5. If any such software existed, I think it likely that he abandoned it and started again whilst employed by MD5. He probably started in late December 2006 and carried out the bulk of the work from January to March 2007. The important point I draw from this is that whatever the precise date on which Mr. Penhallurick first started work on what became the VFC source code as compiled for use in MD5's products, it was after the beginning of his employment with MD5. The first and second works, if they ever existed, have no relevance to Mr. Penhallurick's claim in this action. In other words, I would submit that this is a wholly inadequate basis on which to reject Mr. Penhallurick's credible evidence. Firstly, the case is built entirely on inference, and that is clear from the judge's summary of the defendant's evidence, and it's also clear from the defendant's own defence in this action. In other words, if I can take you to that defence, it's in the same bundle at divider 12. If I can take you to paragraph 8, which you'll find on page 117. So paragraph 8, page 117. As to paragraphs 8 to 10 of the particular claim, the defendant is unable to admit or deny the claimant's alleged development of source code in the period before he was employed by the defendant, and the claimant is put to proof of the same. They then set out various, what they say is the factual background, and actually it may be useful, my lords, just to read through A through to E, because in a way this is where the inferences would be drawn from. So it was just highlighting a few points. I mean, some of these points are more relevant to works 3 to 8, but as we're looking at this, it makes sense to make the points now. In regard to A, the interesting point which comes about A is that it was only once he started that he revealed the methodology. Now, if he only revealed the methodology, the manual methodology, upon starting, it seems very unlikely that he was employed to make the software of that methodology, which of course is the part of the defendant's case. So the methodology is something he didn't know about beforehand. He shows him it on starting, and that's common ground. And they start utilising at that stage. Over the page at paragraph B and C and E, you'll see constant references to the January 2007 date. Now this is really important for the works 3 to 8. This is the defendant's case at the start, saying that right up to, in effect, January 2008, he's using his manual VFC methodology, that's paragraph B. And then little c, at this time, which is a reference back to January 2007, Claimant did not mention to his managers that there was any software available to automate the process or that he was working on developing such software. So clearly, even by this stage, January 2007, they're still not aware that he can even write software, let alone that he is writing it. So if there's anything in existence before that date, the clear implication is that it's not done in the course of employment. It's not something which he's been employed to do because they don't even know he can write software. And then again in paragraph E, it's again very important, that January 2007 date again. So that's the defendants pinning their colours to the mast at that stage, saying yes, it's 2007, we had this discussion. There's then a dispute about, we agree the date 2000 January, we did disagree what the discussion was. But the date 2000 January is the important one. And Lord, you'll see at the end there, it's agreed after that conversation he should spend 100% of his time developing the software. Well, that of course it certainly was agreed that we were going to help write software to bring it to market. That's the security and licensing aspects of it, but not the core functionality. But going back to where I should be, the works 1 and 2, the important point is little f. So on the basis of this material there, on these premises, the defendant infers and avers that no part of the VFC software existed when the claimant began his employment. So all this is inference based on the matters you're seeing up above. And that's also clear when you look at the evidence as summarised by the judge in the paragraphs we looked at a few minutes ago. But the point I would make is that the evidence there does not really justify that inference, and certainly doesn't justify the rejection of the evidence. Looking at paragraph 49 of the judgment, and we go back to divider 8 in the same bundle. And paragraph 49 is on page 87. The first ground on which giving rise to inference is that when shortly after he joined, he demonstrated methodology, but not the software. Well, when I was at that stage, my client accepts that he didn't have a working product. It was simply the starting point of his software. It wasn't a working product, so why would he demonstrate the software which just doesn't work? Particularly as he said he wasn't employed to do it. The second point I make about that is that you've seen from the evidence that my client was clearly sensitive about his works, because the evidence he had given about relation to Cranfield was he had deliberately not written the software whilst he's at Cranfield because he wanted to make sure he retained the copyright. So he's unlikely to sort of bandy around that he's writing copyright to a new employer in case the new employer said, well, I think we would like that. The third and perhaps most important point on this is that we're talking about a time when my client is on a temporary contract, a temporary 3-month contract, which the judge, as I say, there's 4 or 5 references into the judgment. Why would he, as a temporary employee, disclose to them his software? If he's only a temporary employee, he may be gone at the end of the 3 months. He may be in competition with these people. But why would he then, in effect, show them his software, give them a chance to compete with him? And even more so, more relevant for works 3 to 8, why would he then agree that it's theirs?
I know we're not supposed to reply to forensic questions, but might he not have thought that if he's got a valuable asset, a potential commercial use, that he might convert his temporary contract into a permanent one if he...
But I mean, of course, that's exactly what happened in January. So in January, by January, he has produced a working product. And Mr. Clark's evidence supports this. There is a working product by January, which my client has produced. He does show it to them at that stage. And that's exactly when my client says there was then a conversation, in effect, about bringing that to the market for our joint benefit. Now, the parties didn't use the word licenses or ownership. So we are in realms of what we have to deduce from this as to who they thought was the owner and whether it was in the course of employment. But on any basis, that is perfectly consistent with my client's case, that he thought he was the owner of this software. He was prepared to bring it to market in the sense of adding the security and licensing modules that were necessary for it to go to market for the defendant to exploit it, which would be for both parties' benefit. And as my lord suggests, the result of that, of course, was he did end up with a permanent contract. He was carried on. He'd carried on there for another almost 10 years and derived considerable benefit from this because he has paid quite large sums of money by way of the bonus and remuneration for this product. And that's all consistent with my client's case as to what he thought was going on. But the idea that right away back in November, December, when he hasn't got at that stage a working product, he just got an idea, and he's only a temporary employee. The idea at that stage he'd be saying, I'm writing some software, it's going to be for you. It's just not hang together. It's certainly not a basis on which to reject his evidence, which is of course what the judge is doing here. Well, a point one would add to this is that remember, so far as my client, and for that matter the defendant, is concerned, my client's been employed as an analyst, not as a software writer, not as a programmer. And you have to ask also, why would he show them something or give them full details or something, which was very much his thing? This is the subject of his masters. So he had brought this. There's talk about, he always uses an open source VMware, it's called open source software to do this. But that open source software has been around for some time. Nobody else has taken that software through to produce this VFC type methodology and software. That was my client's idea. It was his thesis. You could do the manual methodology, and it was his then carrying it on into the software thing. Why would he want to give that away?
Sorry, just to clarify, it's not in dispute that that the methodology was being used.
Yes.
In his employment.
Yes.
And before 2007.
Yeah, absolutely. Yes. Once he joined, because he's employed as an analyst. And so once he joined, he says, well, this is the tool I use for analysing. This is my methodology, and he demonstrated it to his colleagues and tried to assist them in using it as well. And I think that's all common ground. Yes, as far as I'm aware, there's no suggestion that the defendant knew about the methodology beforehand. Yeah. But certainly once he started, almost immediately after he started, he demonstrated the methodology, the manual thing. But it didn't at that stage. Didn't go further and say that there is the software. And as we've seen from the way the defence has been put, it wasn't until, according to the defence, and we'll look at these dates later on, it wasn't until January that changed. Well, the other point I'd make about this is, of course, as to why he didn't demonstrate the software. At this time, as I mentioned, I think the defendant was unaware the claimant could write software. The next paragraph, is paragraph 50. This is the second basis in which the judge might have drawn the inference against my client. Paragraph 50, having been shown the method, Mr. Green thought that using software to operate the method would speed it up. Mr. Penhallurick expressed confidence he could convert it into a program. Following discussions, there's allocated time to do this. But it's hard to see how that justifies anything, because that's consistent with both parties' cases. Yes, so once they were shown, well, we say the actual December software, yes, there was this discussion, and there was a discussion about converting it into the manual methodology. And my client was given time to work on the securitization and licensing points. But that's not a basis on which to reject his first-hand evidence about material existing beforehand. It doesn't really take the issue anywhere. I make the same point really about paragraph 51. It's hard to read anything in paragraph 51 which suggests that there wasn't any software in existence before November. But it shows at the very end, it says that Mr. Boyd, in effect, is saying that he worked on a software from January to mid-March. Well, that's absolutely right. He had worked on it, on the security and licensing aspects of it. So again, there's nothing in that which justifies the quite dramatic stance of rejecting a credible witness's evidence on something he's uniquely entitled to give evidence on. So you then look at what the judge himself said, and this is at paragraph 52 onwards. The first thing he relies on is the appraisal. So this is appraisal from August 2007, a few months afterwards. And the important thing about the appraisal here is it refers to work being done in February, March 2007. So it's very hard to see how this justifies rejecting my client's evidence that there was nothing in existence before November. In fact, this is actually inconsistent with both the defendant's own case and the judge's finding that all the work my client did on VFC after his employment, all the work he did in November and December, was work done in the course of employment. Because here's the appraisal talking about, it doesn't say anything about I did work in November, December, January on VFC for the defendant. It simply says during February, March, I was given time to develop it. And that's exactly what my client's case is. It's exactly what he did do in February and March. If the defendant, if the claimant had done work for the defendant on VFC in November, December and January, why doesn't this appraisal mention it? So it's very hard to see how this is consistent with the judge's findings and with the defendant's case. On the other hand, it is consistent with my client's case. It does match up with what my client said, because yes, February, March is when he did work on it to develop it in accordance. But as I say, if the earlier dates were important, why aren't they mentioned? But those are really, again, all points more relevant for the works 3 to 8. As regards the present issue about what is there in this which justifies the court saying nothing existed before November?
The way the judge expresses it in 54, in the alternative, by saying it may be that Mr. Penhallurick had done something by way of working on VFC software before he joined, but on his own admission it didn't work and was not worth showing to MD5, suggests that the judge isn't coming to a conclusion that your client was not telling the truth about having worked on software, which would, as you say, have been quite a serious finding to make against him and his evidence. He's saying something less than that. He's saying that which he did was either useless or subsequently wholly departed from.
Yes.
And why is that not a finding he's entitled to?
It is a finding. You can see that's why you can say he's not saying Mr. Penhallurick's a liar, and he can maintain his view that Mr. Penhallurick's an honest witness. Although, of course, Mr. Penhallurick's that doesn't fit. The judge's characterisation there doesn't actually fairly reflect the evidence, as we'll see in a minute. Because Mr. Penhallurick's evidence was, he didn't claim this as a work in program. It was work in progress. But the evidence Mr. Penhallurick gave was he continued developing that software. It carried over into the later versions and is still there in the later versions. So it wasn't ever abandoned. So that's where the judges either he disbelieved or that was wrong, or he found it was abandoned, and that was contrary to the evidence as well, as I'll show you in a minute. And again, on that point, of course, the judge is disbelieving my client. My client is saying that it was work in progress, it wasn't a final thing, I didn't abandon it, I carried it on. And so the judge has rejected that evidence, and absolutely wrongly.
Was it put to him in cross-examination that it was abandoned?
My lord, I don't recall seeing that. My lord friend will know that correct if I'm wrong. I don't think that was put to him in those terms.
And presumably you submitted aught with it.
Yeah, I do. I mean, again, the trouble with IPEC, and I again argue against myself in a way here, is you've got such limited time for the cross-examinations, and you're cross-examining on certain specific issues. But you're right. You would have thought this would be a high on the list of things to be asked. I don't remember seeing it, but my friend no doubt will correct me in due course if I'm wrong on that. But I say it's unlikely that my client would have accepted it being abandoned because his very case is, and it was carried across, and I'll take you to the actual document which shows that in a minute. So that's the paragraphs 52 and 53. You then turn to the paragraph I would have just mentioned, paragraph 54, where he prefers the defendant's evidence. And so this is essentially a preferring defendant's evidence on matters of inference, the ones we just looked at, paragraphs 49, 50 and 51. That is the defendant's evidence he's saying he prefers. And it's very hard to see much meat in there which just justify drawing that inference. And certainly the judge nowhere identifies why he thinks that evidence is so important, why he thinks that justifies him in rejecting Mr. Penhallurick's evidence. And more surprisingly, the judge actually then goes on to draw a conclusion in paragraph 54, which is directly contrary to the one bit of evidence he's just relied on, the bit of evidence in the appraisals. You'll see that at the end he draws a conclusion that he probably started in late December 2006 and carried on the bulk of his work from January to March 2007. So that's the judge's finding. The one bit of solid evidence he has is the appraisal, and all the appraisal shows is work being done in February and March. So on what possible basis is the judge entitled to find what he thinks the work started in late December? One flicks back to the paragraphs 49, 50 and 51, and there's nothing there, other than the end of paragraph 51, where Mr. Boyd says he started work in January to March.
So, am I right in thinking that your submission is that the finding of a start in late December 2006 is actually contrary to both parties' cases? Because the defendant's case was he started at earliest January 07. You say he started well before December 06.
Yes, the claimant's case is that he started writing it in September. There's a bit of a break in October when he was looking for a job and moving house and the like. He then picked up at it again after starting his employment, and he had what he calls his breakthrough in December. And so the September software by December had become a working product, albeit not marketable, but a working product. He says he then showed it to the defendants in January, and they were all very excited about it, and they agreed to go ahead with their mutual benefit. The defendant's case is rather more difficult to pin down because it's been a change. You're seeing in their defence, they're quite clear that the January 2007 date is the first time they knew anything about the software. That's what their pleaded case was, it's what their witness statement says. Those, of course, are all before my client found the documents which showed he had done something in 06. So, perhaps not surprisingly, during one of the witnesses' cross-examination, he said, oh no, it wasn't January 07, actually it's earlier than that, I think it must have been November or possibly December we had this conversation. That's what all this is built on. But up to that point, the defendant's case was, it's in January, they were shown, they said they were shown the methodology again. It's a bit confusing, they were shown the methodology from the very start, but Mr. Green, who was the leading light, didn't really become involved in it until January. He was then showed the methodology in January. He then said, wouldn't it be a good idea to convert this into software? And he says that at that stage the work was done in January. So that's what their pleaded case was. By trial, Mr. Green had changed his evidence. So that actually, no, that conversation where I said, well, why not code it into software took place in November or December. And he had to do that because, of course, by this stage, documents had been disclosed which show their work had been done in 06. So the 07 date was not going to work. But one of the problems in this case is one keeps flipping between works 1 and works 2. which ends with November, and works 3 to 8, which starts with whatever happened after November. Because sometimes we're, as I was saying, once we're relying on inferences from later to try and throw light on what happened before, so it gets a bit confusing.
The judge's conclusion that he probably started work in late December seems to chime back to paragraph 48, where he refers to the cross-examination and
yes,
and Mr. Penhallurick saying that 30th of December had been the first attempt at an automatic methodology.
yes. My client certainly accepts that he did work in December, and that's when he had his breakthrough. That's when he turned it into a working thing, which he then demonstrated.
But this is all part of your point that the judge has misinterpreted this passage in the transcript where he,
exactly, same Lord, yes.
where he said he started in December.
Lord, yes. Well, that is then the judge's reasoning for why he rejected the claimant's otherwise credible evidence on this. The point then is that there's nothing else to support the judge's or the defendant's view, but there's a lot of evidence to support the claimant's case that there was something in existence before November, before he started employment. Well, can I take you to the supplementary bundle? It's probably going to be in your first supplementary bundle rather than the overspill one. Divider 22. This document was Exhibit 49 to Mr. Penhallurick's fourth witness statement. And it shows a list of files with various dates. But where this document came from was explained in my predecessor's skeleton argument for the trial. And I quote that in paragraph 21 of my skeleton for today. This is Ben Longstaff, counsel for Mr. Penhallurick at the time. As part of his original disclosure, item 102, C disclosed that he had extracted metadata from old hard drives to create 6 Excel spreadsheets that show file creation dates and times these files were worked on. They're exhibited at MP49 and MP50, and Mr. Penhallurick explains them in his fifth witness statement. The VFC dialogue CPP files he refers to at paragraph 10 are key. They are the core program for the given version of VFC in each case. We will also invite Mr. Penhallurick to affirm the significance of these files in examination in chief. What one sees in MP49 is that there is a VFC dialogue CPP file created on the 30th of September 2006. See that at line 48. And note that one sees on the right of the table all those files stored in My Project's VFC folder. The Microsoft Visual Studio development environment software that Mr. Penhallurick used appears on line 4. And one can see that software was created on the 1st of June 2005. And as I said in a footnote, Mr. Penhallurick did confirm the point in chief. So that's the explaining what this is. The VFC dialogue files, I know this because my clients explained it to me, it didn't mean much to me, but dialogue files are key files in relation to the source code for the program. So they're the ones you're looking for in order to show the program being in existence. But on looking at the document at divider 22, page 289, you'll see along the top it's got a file created. Now, file created said it is important and significant, but it is a dangerous one sometimes to rely on because a file created can be, a new date can be created if you put your file onto a new storage medium. So if you put it onto onto a memory stick and put it into a new computer, you can get a new file created date. But of course, one thing you can't do, or without, you can't legitimately do, I should say, you can't create an earlier creation date than the time when you're dealing with something. So if I put a work onto a memory stick and put it into a new hard drive, it will create, the date created will be that date. It won't give it an earlier date. So if I do that, if you see the date is the 1st of September, you know that there has to have been something done with that file on that date. It may have an earlier date, but it can't have been a later date. There must have been something done on that particular date. So that's the file created. last written is the last time a change was made to the to the software in the file. Entry modified again is when a change is made. We've then got, going on to the top, we've got the size of the file, and that will be of some use later on looking at the file. You've then got the hash value, and those hash values are quite important because the hash value are unique to any file. If a file hasn't been changed, even if you put it onto a new storage device, it will have the same hash value. So even if it gets a new file created date, the hash value will be the same. So you'll see in the examples of this in these documents. There'll be a file in different storage with a different date, different file path, a different place of storage, but the same hash, which means it in effect is the same document. And I think that's common ground between the parties. So certainly Mr. Clark, the other side's expert, says that. Just one side track on this. You don't see it on this particular document, but sometimes the hash values are described as the MD5 hash, or the MD5 value. That's not actually a reference to this defendant. It's actually the defendant is named after the hash symbol rather than the other way around. So if you see an MD5 hash, that doesn't actually tie it to this defendant. It's just the generic description of that type of file entry.
Can you just tell us on what this document actually is? First of all,
yes, it's
described as an Excel spreadsheet.
Yes,
I mean, that's something somebody's created.
Yes, it's created by my client, and he was asked about this. The trouble is that the software is on an old computer, and the old computer no longer works, but you can find out the file information from it, and this just simply copies what the file information was about all these files.
So he copied out from his computer and entered these things into an Excel spreadsheet.
Into the spreadsheet. I'll check that. That's my understanding of it. My first is it's a forensic extraction is what you do. You interrogate the file, and this is the material it comes out with, and this just records it into the spreadsheet. Mm-hmm. So, but also that's going across the top, and you see the final thing on top is full path. So that describes the whereabouts the file is actually stored. And running down the left-hand margin, you'll see the list of the actual files. And about halfway down, you'll see program files. And they're dated May 2005. Below that, VC60 IDB. Then there's 5 VFC ones, then a res, then 2 more VFC ones, then a whole pile more VFC ones, going down to just above where the number 289 appears. You see the VFC dialog CPP file, which is referred to in the skeleton. So the significant point about, I just took a marker and marked in one colour all the entries which say 30th of September 2006. So all the ones on that first column, file created, they're all created on the 30th of September 2006. So all those files must have been in existence at that date or earlier. It's just they've been copied onto that particular path, that particular storage medium on that date. Then you've got your last written column next to that, and you'll see that what's particularly interesting is they put out a page, just for example, VFC-XE, file created 30th of September 2006, last written 23rd of December 2006. So you see and going down that second column of dates, there's quite a lot of them are the December date, and there's some September dates. I've got myself caught in my seat. So you see that the second column, there's lots of references to the December date as well as the September date. And then the third column, entry modified, all of those ones on that page are December dates. And my lords, two immediate points spring out of this, which don't seem to be unclear or uncertain in any way, is that files are in existence in September 2006. Lots of files with VFC categorization on them, and including the VFC dialog CPP file. Admittedly, it's not a particularly big file, And you'll see that the byte size for the dialogue CPP file is 8,257. That's quite an important figure because we'll need to bear that in mind when we look at Mr. Clark's evidence. So it's not a particularly big file, but it's there. But so that's the first point. It's there in September. The second point is the second column showed, the second and third column showed that these are still being worked with in December. So it makes the judge's conclusion that these files have been abandoned in some way very difficult. Turning over the page to page 290 in the bundle, about the first 10 or 12 entries are again very much the same. You'll see that they are mostly September 2006, modified in, or last written or last modified in December for the most part. And then after about 12 entries or so, it moves from 2006 down to 2009, which is presumably when one of the later versions has been worked on. So turning over the page, again, there's more 2009s. Over the page again, page 292, more 2009s to the bottom where it's 2019. Is the date created file. So that's presumably they've been put onto a new memory stick, something in 2019, presumably for the purposes of this litigation. But over the page 293, we come back to 2006. And there are a lot more files here. Some of them are the same files that we saw on the first page, but they've got different paths, so they're stored in a different place. But they're the same file because they've got the same file name. They've often got the same hash thing, and they're often the same size. Not always, but often they are. So again, these are the same point about these. As all of these ones, well, virtually all the ones on this page, apart from the top three, are 2006, September 2006. Many of them are worked on in December 2006, again making the point that A, it's existed before employment, and B, they were still being worked on and therefore not abandoned. Just looking at the very bottom, this penultimate entry on page 293, you'll see again it's a VCC dialogue CPP file. Again, this one's got the same date created and last written 30th of September. And you'll see it's got the same file size, 8257, and then it's also got the same hash value. The hash values on this document have been cut off in their prime. The numbers go a little bit further than that, but you'll see them in a later document. I think you need to extend the table. So the point is that this document shows a huge number of files being created in September 2006, or in existence by September 2006, and it shows a lot of them still being worked on in December. So even if the product wasn't functional, it's still being used and worked on later on.
And is my recollection correct that this is the document which, in respect of which your client originally claimed privilege?
Well, yes, it was done for the purposes of the, I think it's this one. No, I'm told it's not this one.
No, the source code itself.
This was this one.
Yeah, it wouldn't be the tables.
And it was a comparison.
The comparison, I can't recall when that was.
And this one was disclosed. I'm told this document was disclosed at an earlier stage. I think it is dealt with in the other side's evidence, which for that reason. Similarly, that's the first document which we rely on. And clearly this document is not expressly mentioned by the judge, so either it's been ignored by him or it's covered by his comment that documents are too confusing or too inconsistent to be reliable. But one has to ask, what is confusing about this document? I mean, there may be doubts about its derivation, but they're doubts which weren't expressly put to my client, or my client certainly answered them if they were. So what is confusing and what's inconsistent about it? It shows what it shows. It can't be the judge was relying on Mr. Clark to say these are confusing and inconsistent, because he also found Mr. Clark's evidence was confusing and inconsistent. So he wasn't relying on that to reject this evidence. But I should deal with what my own editor, Mr. Conway, says about this document in his appeal skeleton. He deals with it at paragraph 12 12B of his skeleton. It's in core bundle divider 3. Paragraph 12A. The first tranche of files disclosed were text files said to show source code relating to VFC software. These source code files have the STEM VFC dialog CPP. No metadata was put in relation to these. No of ascertaining from the files themselves when they're being created. Sorry, is that? I'm not sure this is the. I'm sorry, I'm reading the wrong paragraph. I think it's paragraph B, which is we're talking about. Yes, paragraph B. Later, a CFE file was provided that purported to show metadata, dates of creation, last modified styles, file size, file path, associated with various VOC project files. This is the metadata referred to in the appeal skeleton, the claimant's appeal skeleton. Data was provided on several hundred files of different types, including several VFC dialog CPU files, i.e. source code. As Mr. Penhallurick explained evidence, these tables are created for the purpose of litigation. The underlying files are not disclosed or made available for inspection. Mr. Penhallurick's evidence was this is because the underlying files were unreadable. What was disclosed was therefore no more than entries in the table. There was no explanation as to the nature of the corruption that meant the files themselves could not be disclosed, nor of the method by which the metadata was said to be extracted, such that the entries in the CSV files could be independently verified. I don't think he was cross-examined to suggest that they were not, that somehow his process to produce this document was in any way inaccurate, however. And certainly the judge has made no finding that they should be rejected on that basis. He simply said that they either ignored them or he said they were inconsistent or confusing. My little friend, later on in paragraph 29A, comes back to this document, and he relies on the fact that 29A. First, it was Mr. Penhallurick's own evidence that metadata of this kind could be unreliable. His written evidence confirmed at trial was that he had failed to use proper forensic techniques when creating and transferring the source code between different locations. The data file creation and modification were all skewed. That's a quotation. Mr. Penhallurick said that this was a particular problem with the creation date, consistent with Mr. Clark's evidence that the last modified date is generally more reliable, but did not suggest it was limited to that. Well, the only skewing creation date would result in a later creation date if you take the file and put it on onto a new hard drive or a new memory stick. That's the only skewing of the creation date. You won't be able to create an earlier creation date. And so the creation dates we see here are likely to indicate that the file wasn't, well, they can only indicate the file was in existence at that date or earlier. In any event, none of these arguments really assists the defendant because I say on any basis these files must be in existence by September 2006 because that's what these documents show. So unless there was something inherently badly wrong with Mr. Penhallurick's methodology when he forensically examined his computers to produce these, the evidence is clear that there was a document in September 2006 and there's no basis in which to find that Mr. Penhallurick's methodology was somehow flawed. And we'll deal with Mr. Clark's evidence in a minute, but I'll note that Mr. Clark, at paragraphs 128 to 130, expressly refers to this evidence, but doesn't suggest that it's actually wrong in any way. But there's nothing in Mr. Clark's evidence that suggests that this metadata can't be relied on for what it actually shows, software in existence in September. Well, that's the first document, which I say supports my client's case. The second document is a supplemental bundle divider 1. This is, thankfully, just 12 pages from what was originally 4,000 pages of source code. What this document is explained in my appeal skeleton at paragraph 22. Again, I'm quoting from the trial skeleton from my predecessor. He says that this document, the original version, comprised approximately 4,000 pages of Mr. Penhallurick's source code in various versions of VFC, recovered from Mr. Penhallurick's personal computers in January 2020. It certainly appears daunting, but in fact it breaks down into sections that each represent a version of the VFC source code. Conveniently, each section of the source code begins with the words bookmark path, so a Control-F search of the document readily allows one to search each section, to find each section in turn. The key ones we point out here are the very first, starting page 282, and that's what we see at page 1 in Supplemental Bundle Divider 1. Page 282, which shows the VFC dialog CPB file was created on the 30th of September. And the second, starting on page 288, and that's page 2 in what's now Supplemental Bundle Divider 1, which shows a VFC dialog file created on the 23rd of December 2006, which Mr. Penhallurick says he created an intense period of activity over the Christmas period in 2006. We say these versions and their dates put beyond any doubt the fact that Mr. Penhallurick was working on the VFC code both prior to and later outside of his work at MD5. But the document is also explained by Mr. Penhallurick in the course of cross-examination. If I can take you to the, probably your second
Well, just before we look at the cross-examination, can we have a quick look at the documents? Because these ones are pretty odd, aren't they? I mean, we look at page 1, and we see date created 30/09/06 at 10:25, last written 30/09/06, 10:10. So how does it get written 15 minutes before it's created? And it's worse when you get to page 4, when it's created 17:02:09, but last written 02:02:07.
But I think I can explain that. The reason for that is the date created is the date when this file found its way onto this storage, this path, this storage device. Last written is when the last substantive change or last change was made to the software included on it. So the date last written can be earlier than the date that this file was created. I don't think that's in contention. I think Mr. Clark would agree that the last written date is the time when they. That's why he says it's a more reliable tool often than date created, because date created will be changed when you take the file and put it onto a new storage, and the date last written will always tell you the last time a change was made to the actual software. So it can well be earlier.
All right, so you're going to the evidence.
And that's also, the last written is important, and of course the hash value is also important. Again, if it's not changed, if the content hasn't been changed, it will keep the same hash.
So where do we go next?
I was going to the cross-examination, and it's in divider 31 at page 473. And this is in chief, in effect, rather than cross-examination. Actually, this is in chief when he's confirming what this document is. So I'm starting just below letter B. Yes, page 282, right at the top of that. So page 282 is what's now page 1 in our divider.
I'm sorry, which page?
Page 473, behind divider 31.
Yeah.
So I'm starting just above letter C. Page 282. I understand this is the 4,000 odd pages of source code which we're looking at. Would you be able to confirm or explain where the source code here was retrieved from? Answer: this source code is from a forensic image of my old home computer system that I was using up to about April 2016, which is when I got my new computer. And in February 2017 it wasn't working anymore. I forensically, unclear, presumably analysed or imaged or something, the hard drive, and that machine does not exist anymore, but this is a forensic image of my old home computer system. Thank you. Now, at the start of that document, page 282, we see a section here beginning at the top, bookmark item 104, and then at page 288, we see another section the same way. Now, I understand that the code is broken up in sections all the way throughout. I just invite you to comment briefly on the first two sections of code and what I've identified starting at page 282 and then at page 288, that's what those two sections are. So the one at page 282 is the very first time I was working on a VFC concept as a program. The next one, i.e. 288, is in December, where I've had a breakthrough. And I've had some more information that came from various sources outside MD5, and I was able to start work on it. Thank you. I hope this is an open question. My learned friend will explore it. I'm sure that in your view there's a working version of VFC by the end of December 06. Yes, there was. Thank you. Are you able to identify that from the documents here? this one at page 288 is my first attempt at automating my manual methodology into something that's easier for end users to use than a manual method. So that's possibly where the judge got his comment about the first attempt at automating manual method. As you'll see that it's very clear from earlier that he's talking about 282 is the first one he's working on, and 282 we know was September. The next one is in December, it's 288. I've had the breakthrough.
Sorry, are you suggesting we read first attempt as first successful?
So, Lady.
Are you suggesting that we read the reference to first attempt as being first successful attempt?
But yes, that's right, because the earlier, the September version was just the very start of it, if you like, and it wasn't then a workable thing. It didn't actually result in something you could use. It was just the initial writing of the first bit of the software, which went into the final version. But again, we'll see that in a bit more detail in a minute.
So 282 is page 1 of divider 1.
Yes.
288
It's page 2.
is page 2, is it?
So looking at those documents, so on page 282, then you'll see the full path. So that's main OS, which is one of Mr. Penhallurick's computers, and then it's got the rest of that file path there, ending with VFC dialog CPP. File name is that same name, VFC dialog file PP. Created and last written. Then the full hash value is set out there. And then you'll see that it starts with the coding, the source code there, include SDDAFF, they include, you'll see the fourth and fifth entries, include VFCH, VFC, dialog H, etc.
Forgive my ignorance, what language is this written in?
C++.
Okay.
So that's the first document. So clearly on its face, nothing confusing about this on its face. Clearly it is a document from September 06, and my client's evidence is that this is created by the forensic examination of his old computer.
Okay, and going back to my lady's question on the transcript, I presume you rely upon the fact that at G, the question that he was being asked was about the working version.
Oh, absolutely, yes.
Whereas on his own evidence, it didn't work prior to that point.
Yes. Of course, as soon as it worked, my client did show it to the defendants with a view to getting it exploited both, and if some mutual, excuse me, to the mutual benefit. But he waited till it was working before he did that.
And his case, he did that in January.
Yes, he finished it in just before Christmas. His evidence, because you've seen the dates in the file, 23rd of December, etc. And then he showed it he actually demonstrated the software as my client's case in mid-ish January. And that seemed to be initially common ground. It seemed to be initially common ground. There was something in mid-January. The only issue is what was shown to the defendant. Was it just the methodology, or was it the software? To which we would say, well, why would he show the methodology to them in January? They'd seen that from the very start. They'd seen that from the beginning, back in November when he first started working. So why would he be showing them the methodology again? The significance of the January date is he's showing them something different. He's showing them his new software he's now written. And he's suggesting we can market it, or the discussion is we can market this. Whereas the defendant's version of that is it just doesn't really hang together. Why would he show them methodology in November, show it to them again in January, and then be suggested that let's write it? So that's why, presumably, Mr. Green changed his case, changed his evidence, and said, well, actually, no, it wasn't in January we had that discussion, it was right back at the start. His trouble is that it's contrary to his pleaded case, it's contrary to what Mr. Boyd said. So I'll take you through that, the evidence in due course. So you've seen what my client's evidence about this is. This is the result of the forensic imaging of his computer, not something which he was challenged on in cross-examination. And when we look at Mr. Clark, there's nothing in Mr. Clark to undermine that evidence at all. And whilst Mr. Clark couldn't ascertain the dates himself, he was able to ascertain the hash values, and the hash values then can be cross-referenced to document divider 22, the list of the files, and they have the same hash values there. So this document dates, there's no reason to doubt this document. Well, so that was the second document which provided considerable support for my client's case. The next document is divider 4 in the same bundle. And this is these are comparison documents which my client excuse me,
Can you just give a page number, please?
page 27 behind divider 4. There are actually two different documents here. The first one, if you see at the bottom, I'm sorry, it's page 26. I'm sorry, ladies. Page 26. You see at the bottom of that page, looking at a landscape form, it says page 1 of 56. So what this particular document is a comparison of the December software with the software which was first marketed by the defendant. So on the left-hand side, you've got the December software, the one from the source code, which had at divider 1, page 2, and you can check that you can check the software entries there against the page divider 1, page 2. It's the same. So that's the December on the left, and on the right-hand side is the version as marketed, I think in March by the defendant. So that's pages 1 to 56. After page 56, you start. There's a different file which says so now page 82 of the same divider. At page 82, you'll see that it's page 1 of 27. And what this is a comparison between the September 06 software and the December 06 software. So in a way, we should be starting with this one rather than the one earlier in this divider. So what's significant about this is you can see that where it's not highlighted is where the software is the same. Where it's highlighted is where there's differences. So clearly looking through this document, there are reasonably substantial amounts of software from the September 2006 program which have found its way into the December software. December being when my client said he had his breakthrough. Yes, there clearly are also fair numbers of changes, but there are substantial amounts of software which are the same. Now, the significance about this is, firstly, it shows that there was something in existence in September. Secondly, it shows it wasn't abandoned, and there was no sort of starting again. Thirdly, it shows, well, the same point really again, it supports my client's case that this was work in progress, producing a working product, continuing work which had already been started before employment.
And sorry, by highlighting, you mean the things in yellow are the changes?
That's the changes,
Oh, yes.
So
Just they're on both sides of some of the columns.
That's right, yes. So you'll see there'll be differences between those. So, for example, the very first page, I suppose, I'm not quite sure why.
Well, the first one is commented out, so it's double slash. So double slash is comment,
Right.
and classic programming technique. Rather than delete it, you commented it out.
Right, my lord, you're already beyond my computing skills, I'm afraid. So, but yes.
And then we've got some new lines
Yes.
starting with hash include.
My lord, yes. And there clearly are substantial amounts of new material, which, as you'll see, particularly as you go through this file, which is consistent with my client's case that this is when he had his breakthrough in December. But it's also consistent with my client's case that there was something in existence in September. It was carried across into it. He was working on it, and it's not something which was abandoned. Well, so that then is the third document which provides support for the existence of material in September and material which was not abandoned contrary to the judge's conclusion. The next thing I'll take you to is the evidence of Mr. Clark. Now this is the evidence we touched on earlier. It's divided 24 in the supplemental bundle. So this is the evidence which came through about 10 days before the trial. And in fairness, responding to evidence which is only very recently disclosed by the claimant. So it's not I don't criticise the defendant. But you'll see it's a 42-page statement, clearly of an expert nature. As we discussed earlier, it's something the judge admitted, so without prejudice to whatever we wanted to say about it later on. But clearly it's...
Well, I mean, you see it very clearly from paragraph 3. I was asked to analyse the documents and provide my conclusions as to what they could show about the development of the FC source code. So this is blatant expert evidence.
Yeah, a lot of expert. Yes, that's right, exactly. And you know, I can see why it won't be put in at a late stage, because they've only just seen the documents which it's responding to. It actually deals with 3 different categories of document, 2 of which are disclosed by the claimant late, and 1 of which was disclosed by the defendant late, and that's what he identifies those at paragraph 2. The 2 A and B are the defendant and claimant's disclosure, 2C is the defendant's disclosure.
On what basis are you asked to look at this evidence?
Well, for start, my only friend is his part of his case is that the judge shouldn't have treated this as being confusing and inconsistent, you know, because there's valuable material in it. But also, my side didn't seek an adjournment when this evidence was put forward, and the judge's judgment, when he allowed it in, said his final paragraph is along the lines of adjournments are virtually never allowed in IPEC. So, Mr. Longstaff, are you going to ask for an adjournment? My predecessor said, well, we're keen to get on and have the matter heard now. So, and we're not appealing that. So the evidence has been admitted.
What exactly then holds that it's inadmissible?
Insofar as it's expert evidence, yes. So he will what the judge actually said about it in his judgment in the core bundle at divider 8. He starts with it at paragraph 34, so page 85 in the core bundle. I'm starting at paragraph 35.
Yeah, but look at paragraph 37.
Yes.
Objection on the ground that they consisted of disguised expert evidence. They did.
Yes.
No permission.
Absolutely. And then he goes on that the second and third have been filed to offer explanation of spreadsheets and principle, that's sort of executable computer files, which made up late disclosure of Mr. Penhallurick. I just pointed out that actually 2 of them were from Ms. Penhallurick, 1 was from the defendant, which was already referred. This disclosure went to a central issue at the trial, whether Ms. Penhallurick had written the VSE software before he became an employee in November. My impression for the trial, when the admissibility of Ms. Clark's second and third was challenged, was I had no prospect of properly understanding late disclosure without some informed assistant, and not just for Mr. Penhallurick. I allowed MD5 to file Mr. Clark's second and third witness statements to provide an explanation. I did not give them permission to be filed as expert reports, leaving the parties to argue whether Mr. Clark's new evidence was admissible, and if so, what I should make of it once I'd had the opportunity to see Mr. Penhallurick's documents and to hear what he and Mr. Clark had to say about them. So we're in a bit of a no man's land about this. We've got evidence admitted at the very last in it, dealing with documents disclosed at the last
look, Mr. Caddick, it's not your fault, but on the face of the judgment, the judge contradicts himself, because in paragraph 37, he says that the witness statements of Mr. Clark consisted of expert evidence, which appears to be entirely correct. He then says in 38 he didn't give permission for them to be filed as expert reports. So what's left? So that, as I say, is not your fault. The judge has contradicted himself. But But the question my lord asked is, what's your position having regard to what the judge has said about this evidence?
Well, I think all one can look from this to say, insofar as Mr. Clark is giving evidence that can properly be looked at as evidence of fact rather than expert opinion, it is admissible as evidence of fact. But it's very hard to see what factual evidence he could really give, because he's only dealing with documents which have been given to him.
I'm sorry, Mr. Caddick, maybe I haven't made my question clear. Let me try and be more precise. Is it your submission that Clark 2 and Clark 3, being expert evidence for which there was no permission, was simply inadmissible, therefore we cannot look at it? End of. That's one position you could take. Another position you could take would be to say, well, even if it was admissible, it does not impeach Mr. Penhallurick's evidence as to the significance of the dates of 30th September, etc. That's another possible line that I suppose you could just about take. Or are you trying to take some third course that I haven't yet identified?
Well, the truthful answer is probably a third course, because I'm waiting to see where it takes me, which it looks most...
Well, it's your appeal. You have to make the submissions on behalf of your client that you think fit.
Well, the way I prepare my submissions is pretty much along the second line. There are elements in that which actually provide some support for me, which is why I'm as happy to take you to aspects of it.
Right, so as I understand it, your submission is this. You say the judge was entirely correct to say that large swathes of this is expert evidence for which there was no permission, therefore inadmissible. But to the extent that there was admissible evidence, it assists you rather than hurts you.
My lord, yes.
Right.
And whilst we're looking at this, it's interesting to see how the judge then went on to deal with the issue of Mr. Clark's first statement, which of course was also expert evidence, and when it dealt entirely with the counterclaim issue, whether there was a infringement.
Yeah, well, we'll look at that separately.
But,
So what do you want us to look at in Clark 2?
Okay, just the judge rejected that evidence because it was expert evidence. So,
Yes, indeed.
well, yes, if I can get back to Clark 2 then. You identified what the witness has been asked to do. He's asked to analyse and provide his comments. He comments at paragraph 5. I note in my statement it refers to file and metadata timestamps. The events described occurred over 10 years ago. It's not been possible to examine the original computer hardware or determine the accuracy of the system clock or the time zone settings at time. Timestamps that I refer to therefore solely based on the historic data provided to me. We're carrying on then to, he deals with the item 104, which is the source code. So, if I can take it to page 298. Paragraph 20. He says the source code be provided to him as a secure egress email in a zip file. He extracted the zip file to a local drive and marked the extracted files read-only for this sort of thing. Paragraph 22, I noted that the zip file has 2 distinct folders. Penhallurick 103, which is 6 PDFs. That I think is the comparison we're just looking at. Source the submarine bundle 4. And then Penhallurick item 104, which is the 79 versions of the VFC dialogue CPP source code. That's the extracts of which are at bundle divider 1. Paragraph 25 is what I noted that none of the 96 files appear to any meaningful file timestamps. Well, we're not sure why that is, because you've heard Mr. Penhallurick's evidence, which was that the source code you're seeing at divider 1 was produced by interrogating the files in his system, and it did produce meaningful timestamps, the ones we looked at earlier, the time created and the last modified thing. So it's not clear to us why Mr. Clark wasn't able to have meaningful timestamps. To some extent it doesn't matter, because it does seem that he was able to find the hash values, and the hash values are the same as the hash values on our system. Paragraph 26, I concluded the omission of meaningful timestamps made it would not be possible to understand the timeline by direct observation. Unfortunately, because given files with meaningful timestamps, I'd anticipate they're better able to form a reasoned view about the evolution of the software. I conducted a preliminary analysis of the sample of the 1969 files. I noted that each file was called VFC dialog CPP with one exception, file 1, and appeared to primarily consist of the implementation of the DFC digital dialog class. I know from previous experience of the VFC source that that's the main VFC application dialog. I noted that other source code files I expect to see in a contemporary project backup were missing, concluded it mean it be not possible to successfully build a supplied source code and directly examine the functionality by execution of the resulting program. There's just pausing there, nothing so far to undermine my client's case at all. It's just the limitations on his researches. I can go to paragraph 33 on page 301. Having made various observations, he states 3 conclusions. It would not be possible to build a timeline from the supplied source code because meaningful timestamps are missing. The supplied source code was incomplete, not possible to compile the supplied source code. It may be possible by reading and comparing the individual source code files to build a better understanding of the evolution of the code. That would be time-consuming without additional evidence, but not without time to be determined. Based on these conclusions, I reasoned that a really practical starting point for further analysis would be to order the files by increasing size and examine the files in that order, with the initial hypothesis that file size is likely to increase with each successive version as more features are added. And then he does that and exhibits it at JC5. And you'll see JC5 records the file path name and the MD5 hash. You remember I mentioned it's MD5 not used in relation to the name of the defendant, but used in relation to its generic computer speak word. So he's ordered them into orders of size. 36 says based on experience developing C, C++ software. In my subsequent experience, I examined the supply codes, I logged my observations. Several of the files are duplicates of others. This can be confirmed by the identical file size and the MD5 hash value. The duplicates are marked by a capital letter in the spreadsheet and are skipped in the following analysis. E.g., the 2 files marked A are identical. Well, it may be worth then going to now to Exhibit 5. It's one of the more recent documents. Should be behind tab 36. Sorry, no, tab 35. 33. Sorry. Tab 33. My circumstances have printed it on an A3 because it was when A4 became impossibly small to look at. So this is Mr. Clark's extraction from what he's been sent. Hopefully you're looking at a document like this.
Mm-hmm. Yes.
Tab 33.
Yes, it's page 609 if that's any help, maybe.
Thank you.
So looking at the document, in the extreme left-hand margin, you've got the hash symbol. So these, when he refers to a hash number, it's that number there. And the key ones that we'll be looking at are 15, 16, and 18. You then, and the next to the hash is the local path, so that's where he found where the file is to be found. And there's a file name, the size, the MD5 hash. And I say that's MD5 being used in not in relation to the defendant, but those are all the unique file names for each individual software. And next is it a duplicate or not? And then final column is notes. So, and the duplicates, you'll see that the items 2 and 3, or hash 2 and 3, are both little a because they've got the same hash. So, although they're stored on different places, you can see from the local paths are different, they are the same document. That's clear from the hash and from the size, which are both identical. For present purposes, the important ones, I say, are 15 and 16. So, 15, it gives there the local path, and you'll see it's a different local path to the one at 16. But in the next column, file name, the same file name, and the next column, the size, exactly the same size. That's the 8,257. Remember, we saw that figure in divider 22. Something in divider 22. That's the same thing from Mr. Penhallurick's thing. We then got the hash, and again, those identical hashes. So items 15 and 16 are the same file, just in different places. So looking at that, The file name and the hash show that he's talking about the same document that was at Supplemental Bundle Divider 1, page 1, the source code, which was September 2006. So we know from the file name and the hash that this is the September, hash 15 and hash 16 are the September documents that he's talking about. Similarly, we know that because it's got the same file size and the MD5 hash. Again, you saw that file size, that MD5 hash, both in the document at divider 1 and the document at divider 22. That's the document he's now referring to. So going over back to his report, and if I can take you to page 302 at little letter D, it's when he describes what document, what hash 15 and also therefore hash 16, because they're the same document, are about. So this is the September 06 document he's talking about. File hash 15 is the next largest file that appears to be from early VFC. It contains an implementation of the main VFC application dialog class.
I beg your pardon, it's my fault entirely. I've made a wrong note of where this witness statement is. Could you
divider 24 in the supplemental bundle.
Thank you so much. And you're at 302. 302, thank you.
So he's now referring to the spreadsheet we're just looking at, and he's going through each of the hash documents to explain what he makes of them. So little letter D on page 302, he's describing what these hash 15 and therefore also hash 16, because they're identical, is about. Hash 15 is the next largest file, appears to be from early VFC. It contains an implementation of the main VFC application dialog class, CVFC dialog, and another class to display the application about dialog, CAbout dialog. The code is missing a definition of the ID about box dialog, and thus could not be successfully compiled in this form. The code performs an enumeration of the attached physical disk and displays the resulting drive geometry. The enumeration code appears very similar to a Microsoft example currently available. It contains the same basic structure, junk variable, name and comments. I would conclude that it is likely this code started from the historic version of Microsoft example. As previously noted, the code is missing other essential source codes such as, and then he lists those with the UI user interface dialog templates. So he's talking there about the September software we've just been looking at. It's clear from that he accepts it's an implementation of the main VFC application dialog. He's clear that it involves an enumeration of attached physical disks, which is a very key role for VFC. It allows you to replicate a disk in a virtual environment and therefore examine it forensically without changing anything. It may be similar to the Microsoft example. I mean, there's no evidence as to what the Microsoft example is, but there's also no suggestion anyone else has produced a product which does the same job. But he admits that it must have been altered, because he says it would conclude that it's likely this code started from the historic version. So it started from, but it's moved away. So then his comment, just above letter E, his comment is, I would characterize the drive enumeration code as a precursor to VFC, but not specific to the VFC method. In my career, I've worked on several non-VFC projects which contain similar code to perform this common task. So that's where he's dealing with the September software. The next little letter E deals with file 18. Now, file 18 is the December software, and we know that from looking back at the spreadsheet at page 609. The spreadsheet for hash 18 gives the file path and the hash and the size and the name, all of which are consistent with the information on Supplemental Bundle Divider 1, page 2. So we know he's talking about the December software. Nothing later, this is December. So he says, little letter E, file 18 is the next largest non-duplicate file, appears to be from early VFC. It is approximately 38 kilobytes larger in size, and I would conclude represents a significant step in the previous code in 15 and 16, in fact, is identical. Based on my previous experience in the VFC code, this file is the first one to contain elements of what can reasonably be described as a VFC method. The code references UI elements, user interface elements for the VM name, disk name, OS, etc. Then his comment, This code appears capable of enumerating partitions, several different methods present, creating a VMDK virtual disk file, mounting that VMDK, loading, injecting and loading the guest OS registry. Code is arguably primitive, it is minimal error handling. For example, for instance, it performs many functions by spawning external tools built into the Windows operating system and displays limited error messages. In other words, users program will be using it blind, assumes hard-coded paths for the guest OS folder, and as such, it may have worked on a developer's computer, but would be unlikely to work consistently on another user's computer, where these prerequisite assumptions were not true. It also assumes something else. There's comment. In my view, this is the first code that could be objectively described to contain the VFC method. I would characterize this code as an early proof of concept. It may have worked, but was very crude and contained minimal error checking. It would probably only have worked on the developer's PC and assumed the target guest operating system was always Windows XP Home. So that's talking about the December software that my client very briefly before any conversation with the defendant. He then goes on to deal with the various other versions, and we don't need to sort of trouble with those particularly, but if I can take you to paragraph 37, there's quite a few pages where he deals with various other files, hash files, but we can take you to paragraph 37 on page 307, and this is where he summarises his observations, and if I can start at subparagraph D, file hash 18 could best be described as proof of concept. This is because it included minimal error checking, displayed fewer messages, made many assumptions about the operating environment, and only targeted Windows XP Home as a guest operating system. Based on my experience as a software developer, I would doubt this code would have been expected to work on any computer except the developer's PC. I do not believe it could objectively be described as a finished or polished product. Well, my client's case has never been that this was a finished or polished product. My client's case has been this was, however, a working bit of software. And
sorry, you've skipped to D, which is understandable given time constraints, but nevertheless A to C are actually quite important as well.
Well, they are, yes.
Because he thinks that code sizes increase with each version, comments through the code, and evolution is reasonably understood. So in other words, this is all evidence of software in development.
Well, yes, absolutely. The one thing I would qualify that with, which is not in my interest, is that the hash, he's only ordered by way of size. He hasn't ordered by way of dates because he said he doesn't know the dates. So the earlier ones before hash 15 may or may not have actually been earlier. They may have been, they may just have a lower hash date because they are smaller files. But the premise is absolutely right. What he's describing is a software in development, software in progress.
Yeah.
And the description of the December version, proof of concept, it would work on the developer's software system and maybe not somebody else's. Well, proof of concept is quite important. It proves the concept. It is a working bit of software. And if you can turn over the page, you'll see a table where he sets out, it's quite a useful table, where he just sets out in table form his conclusions. So the first, and actually little letter I is, makes my Lord's point again. It's very much my Lord's point just there. Each iteration shows an increasing depth of features, support for further guest operating systems, a more polished UI, a gradual removal of the limitations and assumptions present in the earlier code. All of this work would have contributed to VFC becoming a functional product. So, Lord,
sorry, that description would include, it's by reference to material that is also after December 2006.
But it is absolutely right. So, of course, the difficulty of after what we say the January conversation is, so we say that the core software, the VFC functionality, which was and remained ours, insofar as we did other bits, like he talks earlier about adding the dongle, which is a security device to allow a user, a licensee, to use it without being able to get through to the underlying software. That stuff that my client admits he did for the defendant because that was material which allowed them to take this product to market. So that was done for them. And so, yes, and those elements of that would have gone on into the program as sold, but wouldn't have been affecting necessarily the core functionality of the program. Then at the table, he sets out his comments about the various different versions, and hash 15, which I say is also hash 16 because it's the same file, is the September one. Code to enumerate physical disks, it's very similar to Microsoft. A prerequisite for the later VFC method, but not unique, so not unique to it. The hash 18, first version with UI elements, familiar from later VFC. first version to include a central code to do X, Y, and Z. Then in the right-hand column, it's the first version to contain the VFC method and certain UI elements. At this point, key components of the method were understood but not yet fully working. In my view, this is best described as proof of concept. And actually, just interesting enough, looking at hash 21, you'll see added key lock dongle code. That's for one of the security elements that my client accepts was done for the bid in order that it could be marketed. In fact, the comment in the right-hand margin there, this suggests a distributable project is under development and it's desirable to secure it against unauthorized use. Whereas if I can take you on to paragraph 38 on page 310, again, it's my Lord Justice Arnold's point, paragraph 38, I would conclude that this exercise showed the evolution of the early VFC version 1X from an early proof of concept through a period of significant development to a version that required a dongle and a period intended for initial end-user distribution. Paragraph 39, I would also conclude this exercise did not establish when the development work took place. This could potentially be achieved if meaningful timestamps or other project files with embedded metadata were available. And my Lord, he doesn't say you can't get that, and of course that's what my client's evidence has shown, what the timestamps actually were, because that's what we saw in documents 1 and 4 and 22 in this bundle. But he then goes on to deal with a comparison. I don't think you need to trouble with this, because in paragraph 40 onwards he's dealing with later versions, so after February 2007 onwards. So if I could take you through to just look at paragraph 44 on page 314. Just a very quick comment on that. He says, taken together, I conclude it's likely that source code file hash 24 was under active development around the 6th of February. So if your file 24 is under active development in the 6th of February, that suggests the other files are somewhat earlier than that. There's a limit, there's not a particularly valuable point. Over the page, I'll refer you to paragraph 50 just for what it's worth. I executed the installation package and noted it displayed the following license agreement referring to MD5 as a licensor. So it's something my learned friend may want to rely on, but of course the licensor is not necessarily the owner of the software. If I can then carry on to page 318, anyway, this completes that last point I just made. A little f just below the picture there. The program contained a dialogue template for the about dialogue with the MD5 Ltd logo and stating VFC version 1.0.9 copyright 2007. Lower down, VFC is written and developed by Michael Penhallurick, copyright 2007. Now, that is a significant date. This is a product being marketed by the defendant, and it has Mr. Penhallurick's name with the copyright logo next to it and with 2007 next to it. Now, yes, it doesn't say earlier 2006 or 2005, but the very fact it says 2007 suggests that in 2007, certainly Mr. Penhallurick, and probably one would have thought MD5, are assuming that he is the owner of this copyright. Over the page, you see actually the picture showing that. VFC is written and developed by Michael Penhallurick, copyright 2007. So the very time that this product has been first brought to market in 2007, that's the copyright notice, which is there. Over the page 320, and paragraph 56, after I complete the analysis in section A, I understand the early VFC project backup listings were disclosed with Mr. Penhallurick. So this is the document 22, divided 22. Referred to him by the secure egress email attachment by Mr. Boyd. If I can take you to paragraph 64 over the page. So this is, he's got the 6 different listings here. He's merged them into a single Microsoft Excel spreadsheet and added a column to indicate where he came from, and he then exhibits that. We don't need to go to that because he actually helpfully attaches an extract from over the page. But paragraph 66, he then deals with what he's found and the types of files. And over the page, paragraph 68, he says, I noted that 11 of the files in the system were named VFC dialog CPP. This is the same file name as the 69 files. That's the ones in item in the source code in divider 1. same file name as the 69 files I previously reviewed, and based on my experience, the source code could be objectively described as a primary source code in the early VFC version 1X. It's marked in red. Then he sets out in the table below what he's found on this material. And you see the very first item on the table, that is the #15, #16 document. It's got the same file size, 8,257. So that's the same which we saw in for example, supplement 1 or divided 22. It's then got the last written date is the same, and it's got the full path, which is the same that you'll see on supplement 1 or divider 1, page 1. So that is #15 or 16. The fourth entry in that table is #18, the December version. So the first one's a September one, this is now the December one. And you'll see he's given the file size now, 47,459. And that's the same file size that was in Mr. Clark's earlier spreadsheet at JC5. So we know this is #18 because the file size and because the file path is the same as well as you'll find in supplement bundle divider 1, page 2. What's interesting, one can note about this thing here is he's got the date, the 30th of December. He's got a time, which is 9:15 in the evening, and the 30th of December. 30th of December was a Saturday, and the time obviously is 9:15 in the evening. So it doesn't suggest that's been done at work. The last written thing, it's quite interesting if you look at the asterisk just below the thing. I've used the last written timestamp rather than the creation timestamp because it indicates when the file was most recently updated. This is a point I made to my lord earlier. When most recently updated, and based on my experience of common file types, it's most likely to be preserved when files are copied, backed up, restored, or transferred to another file system. The other time file fields have different meanings, the most consistent behaviour. So he's saying there quite clearly that the last written is something you can generally rely on. Going down to paragraph 70A, he's examined these 11 files. The 3 duplicate files with a size of 8257 were the same size as file #15 and #16. File size by the 2 of the 3 files that match the hash I previously calculated in these files, and he gives that hash. Therefore, I concluded that this was the same file which I previously described as a code to enumerate physical disks, i.e. #15, #16. Little b, the file with a size of 47,459 bytes was the same as #18, which no file hash was provided for the file. I therefore concluded it may be the file I previously presented as proof of concept. So that's i.e. #18. #18 was the one we said contained the VFC methodology and key user interface elements. He then goes on to deal with the later files, which we don't need to have trouble with. Paragraph 71 is useful, though again he makes the point that last written timestamp is generally reliable. Taking them at face value and based on his analysis above, he summarised this as follows. And then this could be written by my expert, in effect. Paragraph #15 and #16 in the table at the bottom there, last written 30th of September 2006. Nothing there to doubt that. He's saying the last written sentence is generally reliable, and there it is. Over the page, the top of the page, #18, proof of concept. That's my client's December version. And again, these are his conclusions. And then paragraph 72, I think, is very useful. Based on the following, I note the following. #15, 16, enumerate physical disks is reported last written on the 30th of September. #18, proof of concept reported last written on the 30th of December. The subsequent files, 1931, reported last written in effect February to March. So far, completely consistent with my client's case. Nothing to undermine my client's evidence that he created source code in September, developed it in December, and then worked on it after the conversation to make it fit for market in the course of February, March. Paragraph 75 is again worth looking at, and because this could be written by my expert. Paragraph 75, based on the above, I would conclude the reported timestamps for #15 to #31, so that includes all the important ones, 15, 16, and 18, so the September and December ones, appear to follow the anticipated chronology. B, there's a gap in the listing chronology for October, November, and early December. Well, that's again completely consistent with my client's case when He started in September, then, sorry, my learned friend.
My lords, I didn't want to interrupt my learned friend's submissions, but I should just note at this point that the paragraphs that my learned friend is referring to at the moment were not passages from this statement that MD5 obtained permission for. There was an order, and I'm afraid I've just checked it's not in the bundles, but I'll make sure that we get hold of that order under which permission for this evidence was given, and is only actually related to specific paragraphs. So obviously it's for your lordships and my learned friends as to the extent to which this material is still relevant material in the context of this appeal, but I just thought I needed to make your lordships aware of that.
I am grateful, Mr. Conway, and obviously you'll fill us in on the details after the short adjournment. But as you will appreciate, the point that's being made by Mr. Caddick at present is that this material, even if admitted and admissible, is not inconsistent with his client's case.
I understand that, yes. And I just wanted to make your lordships aware of the position.
Thank you.
Miss Conway, of course, was acting, so he would know more about the background than myself. I wasn't aware there was any particular distinction in any parts of his evidence. My understanding from the judgment was the whole statement was proffered, and the whole statement went in on the basis set out in the judge's judgment that we've seen. But I can't comment any further.
All right, but anyway, do we need to look at any more of this?
I think I think the paragraph 75 I think is a significant paragraph. I was going to take you something over the page, but I don't think it sort of doesn't really add much to what I've already submitted. I think I should take you, if I may, to page 328, paragraph 79. So this is his conclusions on this document. I would conclude that taking the listings provided Mr. Penhallurick at face value, the last written timestamps reporting the listings provide a plausible chronology for VOC development. And the last written timestamps for the first physical drive enumeration was on development in late September 2006. Last written timestamps suggest the proof of concept code was on development in late December 2000. That should be 2006. I think the 2007 is.
It's an obvious typo.
Yeah, absolutely. And then paragraph 84 and 85, I think, are some particular significance, particularly 85. I know these conclusions are based on the last written timestamps that are in the supply of the file listing. I've not been able to verify the method used to create those listings. I also note that whilst there are some minor inconsistencies in the timestamps, these are generally explainable, and overall they appear to me to show a consistent chronology for early VOC development. So, as I say, nothing in here to cast doubt on what Mr. Penhallurick says. Documents 1, 4 and 22 mean and show. And I don't need to take my notes here, but paragraph 128 through to 131, he deals with timestamp data. And he makes the point about last written being the most reliable. That's paragraph 131. That was Clark 2. There is, of course, Clark 3. My learned friend refers to this in his skeleton, and I find it hard to see what the significance of Clark 3 is to our present issues. As I understand Clark 3, he's dealing there with an analysis of files provided to him by the defendant, so files from the defendant's system. And perhaps not surprisingly, particularly given my client's case, those files are all dated from mid-January onwards, nothing from earlier. We, of course, say that supports my client's case. The very fact that they didn't have any of this stuff until mid-January is because that's when he showed it to them, and that's when they reached the agreement. He ought to do some of this for the benefit of them both, which is why it suddenly then appears on their systems. I think, as I understand Clark 3, he's pointing out that there is identical file names in the September 06 software as there is in the January 07 software. Again, that's not a surprise. If you're going to work it up into the final version to be marketed, you would, rather than abandoning it, you would take your existing software. So it would have the same hash values because it's the same file. You then work on it, produce something different, and you'll get a different hash file thereafter. So I'm not sure that I can really help much further about Clark 3. It doesn't really, I think, in my submission, take the court anywhere. It was also only filed literally days before the actual trial. But I've got one further thing about other evidence and supporting my client's case, and this is the copyright notices. I think I can probably deal with this before the short adjournment. One bit of evidence is the existence of copyright notices. You'll see firstly, it's a supplementary bundle divider 23. So this is taken from my client's fourth witness statement, Exhibit 51, page 295. And these are all show the copyright notices included in the various VFC software files. And you'll see in each of them there's written developed by Michael A. Penhallurick, copyright notices, and it says copyright 2005-2010 or 2005-2009 or 2005-2016. Now, in other words, the point obviously put to my client in cross-examination is, well, you didn't start writing it until 2006, even in your own case, so why have you said 2005? Which my client says, well, that's when I came up with the methodology. I mean, okay, methodology isn't software, but it goes into the software. So maybe my client is being imprecise about that. But one thing it absolutely clearly shows is that my client believed himself to be the owner of the copyright all the way through the times that these files have been developed from 2005 right up to 2016. Similarly, if I can just take you briefly to divider 6 in the same bundle. These are, so the one we just looked at was just as a result of a search. Divider 6 has actually...
I'm sorry, where are you now?
Divider 6 in the same bundle.
Yes.
These are actually screenshots of what actually appears on the screen. So, for example, the first page, for some reason my pages aren't numbered, I'm not sure why. The first screenshot is the VFC demo version with MD5 in the top. At the bottom, written and developed by Michael A. Penhallurick, 2005 to 2008. So the copyright notice is very definitely associated with my client and not with MD5. And the subsequent pages in that same divider show pretty much the same.
So, and this is an annex to the particulars of claim. So, clearly something that your client was relying upon. And you make the point that both here and in the earlier exhibit we were looking at, we see these copyright notices appearing on the software as marketed. As marketed by the defendant. Now, what was the defendant's evidence about that? As to what was their explanation for the fact that they were marketing a product bearing a copyright notice not in their name but in the name of the claimant?
The evidence from the defendant is they asked him regularly to take these copyright notices off, and he either did but then put it back again or didn't and left them there. They were cross-examined on that, and they conceded there was not a single written bit of evidence to show requests to remove this copyright notices. So on any basis, my lords, it certainly shows that my client's mindset was that he was the owner at all times of this software.
Well, it's even on your case, it's inaccurate, isn't it? Because you concede that insofar as the copyright is in things like the access code and things that are relevant to commercialisation, it does belong to MD5.
Yes, I think, my lord, there are places actually where on those things it does have a different copyright notice. I'll check on that.
The dongle was something that they licensed separately. The other program to manage the licensing is totally separate. Has no copyright.
But yes, I'm told that the dongle, which is marketed together and separately with this product, which was developed by my client for the defendant, does have a copyright notice which identifies the defendant as being the owner.
Yeah.
But the core...
It would be quite helpful to see that. Can we see that?
I'll see if I know.
Is it something that they've got?
It's in a copy of the bundles.
Not as far as I'm aware. It was pro software for them for internal use, and they had staff looking at it.
But my client says that it doesn't think it's in the bundle. I think I have seen something somewhere in the bundle.
Lordships, I think, to tab 21.
Tab 21, my Lord of Friend, sorry, thank you. Because I'm sure there's something in the bundle which has. My Lord of Friend is not supporting my submission, funny enough, he's making a submission against me. That's not surprising me. This is a license manager, and the license manager has my client's copyright notice on it. So it's very helpful to my client, my Lord of Friend, to make a point against me.
That's why are the Greeks when they bring you gifts?
Absolutely. Excellent, well shut down. My Lord, just if there's anything else I want to say about the copyright notices. Yeah, just one final point on this, my Lord, if I may. My Lord Friend in his skeleton argues that the fact that earliest VFC had the 2007 copyright notices on, I think you're seeing, shows, he says, that the earliest versions were 2007. But it's worth actually looking at what the claimant actually said about those 2007 notices. And this is in Supplemental Bundle Divider 31 at page 503. Bottom of page 503, a question from Mr. Conway to my client. And we also see there's a copyright notice to the other side. You see that, yes, again, that is in the resource file, which is not directly in the VOC dialogue file, it's just an additional file that's edited separately. Just as an aside, that is also true of some of the other early demonstration versions, is it not, that you had a copyright notice 2007? Yes, because that's when we were starting to market it. Sorry, so I wanted it to, I'm sorry, I didn't want to interrupt you. Something else to say. No, it's just that the time was brand new in later versions, because it's based entirely on the manual method. I modified it to reflect that I've been doing this since 2005, which is when I published. This is the embodiment. VFC is the embodiment and automation of the manual method as part of my thesis. And you did not, even though you knew you had not even started developing software back in 2005. No, not physically started. The concept was always there. Hence the reason I was told not to develop software as part of my course. So in 2004, I was considering writing the software. I was advised my best interest not to, as I could retain the intellectual property. The natural reading of the copyright notice 2007 is that the work was created in that year. Is that not right? Except that would seem to be the case. So that's as far as that went. But of course, the 2007 date is next to Mr. Penhallurick's name, not next to the defendant's name. My Lord, I don't think. I was going to move on to a different topic now, so I don't think that would be a convenient.
Certainly. How are you doing time-wise?
Actually, I think I'm reasonably up to speed, because we've really covered quite a lot of the ground about the works 3 to 8 already in the course of dealing with works 1 and 2.
All right, so when do you think you might be finishing?
I would hope to finish by about 3, maybe
right.
3:30 possibly, to give myself a little wriggle room.
Okay, we'll resume at 2 o'clock.
Well,